All right, I will call to order the Zoning Board of Appeals meeting for Wednesday, April 12th, 2023. To all person interested in or affected by the actions of the Zoning Board of Appeals, you are hereby notified pursuant to Section 11 of Section 40A of the General Laws of the Commonwealth of Massachusetts and all amendments thereto that a public hearing on the following appeals will be held on Wednesday, March 12th, 2023. Introduction of board members. Myself, Chair Jacob Dewey, Herb Bodenseek.
I'm present.
Your microphone.
Paul Pinard.
Present.
Mark Hanson.
Present.
Aaron Webb.
Present.
Denise Johnson. We have a full board tonight. Notice of recording. Please note this meeting is recorded and broadcast on Channel 18 in accordance with MGL Chapter 30A, Section 20. I must inquire whether anyone is taping this meeting, and please make their presence known. Seeing none, first order of business, we have meeting minutes from March 8th, 2023. I need a motion to approve.
Motion to approve.
And a second.
Second.
All those in favor?
Aye.
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 All right, minutes are approved. First order of old business, appeal number 2022-021, Louis Velmier has filed an appeal of an administrative official's decision in accordance with Section 240-88 appeals. The building commissioner issued a notice of zoning violation and ordered to cease and desist on March 3rd, 2022, which stated that the total number of dwelling units are 4. 3 units in the main dwelling and 1 in the detached barn workshop are a zoning violation under Chapter 240, 11A1 in the RF2 Residence F2 zoning district. The subject property is located at 4280 Main Street, Barnstable, Mass. As shown Assessor's Map 351 as parcel 042. It's located in the Residence F2 RF2 zoning district. This was continued from December 7th, 2022, February 8th, 2023, and we had members assigned, myself, Herb Bodenseek, Mark Hanson, Paul Pinard, and Aaron Webb. We received an email from Attorney Sabat requesting to withdraw without prejudice. Do we have a motion to approve the withdrawal?
So move, Paul.
And a second?
Second, Mark.
All those in favor?
Aye.
Aye.
All right, so that is done. In appeal number 2022-057, Perry S. Wentworth has applied for a special permit in accordance with Section 240-47-2C4, accessory dwelling unit. The applicant seeks to construct a detached 2-bedroom accessory dwelling unit which exceeds the allowable as of right square footage. The proposed accessory dwelling unit is 1,876 square feet, and the as of right size is 900 square feet, thereby exceeding the allowable size by 976 square feet. The subject property is located at 16 Wally Court, Hyannis, Mass, as shown in Assessor's Map 324 as parcel 020. The property is located in the Residence B RB zoning district. This was continued from January 25th, 2023, March 8th, 2023, and members assigned were myself, Aaron Webb, Paul Pinard, Denise Johnson, and Herb Bodenseek. Again, we've received a letter from Attorney Lawler, was that?
Yes.
Lawler, to withdraw this without prejudice. Do I have a motion to withdraw?
Motion to withdraw.
A second? Second. All of those in favor?
Aye.
Aye.
So that is also withdrawn. All right. Moving along, continuing in old business, appeal number 2023-005. TJA Clean Energy Lisi has applied for a modification permit pursuant to Section 248A3B, modification from Section 240-44-2E3, dimensional requirements, and Section 240-44-2F2, special permit provisions. The applicant proposes to construct a large-scale ground-mounted solar photovoltaic installation pursuant to Section 240-44-2E3 of the zoning ordinance. The proposed setback for the solar array is 16 feet from undeveloped land on the westerly side of the property where 100 feet is required. The subject property is located at 810 Wakeby Road, Marston's Mills, Massachusetts, as shown on Assessor's Map 013 as parcel 004, 005, and 052. It's located in the Residence FRF zoning district. This was continued from March 8, 2023. Members assigned are myself, Herb Bodenseek, Mark Hanson, Paul Pinard, and Aaron Webb. Whenever you're ready.
Good evening, Mr. Chairman, members of the Zoning Board. Attorney Mike Ford representing TJA. together with Brendan Reale from Atlantic Design Engineering. He's the environmental planner from that office who has assisted in the preparation of the plan and the filing. Mr. Chairman, I guess I need a little bit of direction from you as to how you would like me to proceed. As you recall, this was continued at our last hearing for a number of reasons. There were certain additional information you asked for from us, which we're prepared to walk through. We also had not resolved all of the issues with the fire department, particularly the access road, and we had an on-site coming up, and the board was interested in seeing if that got resolved and report back to you, and we're prepared to report on that. And in addition to the matters that we had, Town Attorney's Office had also asked that the matter be continued so that they could provide some information with respect to standards and findings with respect to the petition. And I see that Attorney McLaughlin is here tonight, and I know he's provided a memo to the board as well. So we're prepared to go forward on the issues that we had first, if you'd like to proceed in that fashion, but...
Yeah, I think if you want to update us on some of the issues that we raised.
Okay.
And yeah, just bring everyone up to speed.
Okay, fine, we'll proceed in that fashion. So first, what I'd like to do is turn it over to Brendan. He's going to walk through a number of the issues from the plan standpoint and additional information, and also give you an update on the agreement that was reached with the fire department and how that affects the plan. So Brendan, why don't you start there?
Good evening, Brendan Reale from Atlantic Design Engineers. I believe the last time we spoke to you, we were waiting on having an on-site meeting with the fire department, which we did have. After discussing certain aspects of the design with them, they have requested that we widen the access road to 20 feet. So I just wanted to update you on how that would, in the event that we were denied the modification permit, how that would affect our project. Based on the initial layout that we submitted well before this process started, the layout has been reduced significantly. The initial layout has been reduced from 26% from what you see right now. Additionally, denial of the modification permit would reduce it even more by approximately 3,000 panels. That's considering if we were not allowed to have the 100-foot setback, and the access road would be not allowed within the 150-foot setback. So that is roughly a 33.6% reduction in the production of the array and the energy produced into the grid. And Anna, if you don't mind skipping to the next slide.
Before you leave that slide, am I correct, Brendan, just so the board is aware? The area that you outlined in red on the plan is the area in which the modification is requested, is that correct?
That's correct.
And on the easterly side, that represents the area that we're in the 150-foot setback?
That's correct.
And on the westerly side, that represents the area we're in the 100-foot setback from the westerly side, the undeveloped plan?
Correct.
Okay, thanks.
Yep, right there. Yep, thank you. The other items I wanted to update you on were in regards to a couple questions that we had received on the site regarding environmental. Someone had raised the question if previously an environmental assessment of the property had occurred. It had occurred. In 2019, Mass DEP accepted a comprehensive site assessment application, which was prepared to achieve final closure of the solid waste handling and storage facility that was conducted under Gifford and Sons. The CSA detailed substantial cleanup activities to remove all solid waste debris identified by Mass DEP within a previously completed correction action design permit approval. Additionally, the CSA detailed on-site soil testing and down gradient groundwater testing. So they found hydraulically down gradient wells from the site. Testing was completed by taking groundwater samples, and those were sent to a laboratory for analysis. It was indicated within this CSA from Mass DEP that concentrations of contaminants of concern were below Mass DEP standards. Additionally, I just wanted to reiterate a few aspects based on comments that the ZBA has received and that was forwarded to us. Our proposed solar development will not utilize battery storage, and the modules will not contain PFAS. Transformer fluid within the transformers will be biodegradable and is primarily food-grade vegetable oil. Additionally, we've submitted documents from Mass DEP. One document is Mass DEP did a Mass DOER and Mass CEC, which is a question and answer for ground-mounted solar photovoltaic systems dated June 2015. The other one is a document for public water suppliers on PFAS regulations. Between both the documents, they indicate little of any risk of chemical releases from PV panels to the environment during normal use. Also, researchers have concluded that potential for emissions derived from PV components during typical fires is limited to relatively short duration of most fires and a high melting point of over 1,000 degrees Celsius of PV materials. Somebody in the meeting had brought up the question about the fires themselves. That information was derived from a report, and the data collected from the report characterized scenarios, specifically quantities of materials present in residential, commercial, and substation level installations. So their analysis took into account basically the three primary sources of or sizes of solar arrays, which is residential, commercial, and substations. And then finally, Mass DEP has not identified any water sampling results that have detected PFAS coming off of solar panels or PFAS present on panels. And that is my update.
A couple further things that I had on my checklist, Mr. Chairman. One, we provided to you the deeds for the town property to the west, and I'll talk more about that when we go through the criteria again for decision-making. But the deeds are quite clear that the town has purchased the property and holds it for open space and watershed protection purposes. And so it will not be a piece of property that will be developed. It is under the jurisdiction and control of the town manager. It's Article 97 property. And it also is subject to a conservation restriction, the holders of which are twofold. One, Barnstable Land Trust, and also the Centerville, Osterville, Marston's Mills Water and Fire District. So the property, in addition to being held by the town for conservation and watershed protection, also has a private restriction that runs to both the Fire Water District and to the Land Trust. The other thing I wanted to point out is that the site plan review decision that you had in your file the last time we were here has been updated. There was, it's been updated in two respects. One, although this isn't on the March 6th site plan review letter that is the update, we were able to resolve, as Brendan indicates, any issues with the fire department. They did request the 20-foot access road, and Brendan has now shown that on the slide that you saw in red. The other important update was from DPW, and that update reads, the DPW comments pertaining to clarification of hazardous materials to be used in the project and the request for an extension of the earth berm along the eastern property line have been resolved between the applicant and the DPW staff. Request for an extension of the earthen berm has been eliminated. Once they were able to take a look at the stormwater plan that Atlantic had, they realized there was no need for that particular berm, and they have clarified that they are satisfied with respect to hazardous materials at this point, which is something that site plan review is charged with looking at under the new overlay district. So those are changes to the site plan approval that you had in your record from the last time. So with that, Mr. Chairman, I do have additional comments with respect to the criteria under the bylaw and Attorney McLaughlin's letter, but I'm happy to, at the board's direction, wait. If you're going to hear from Attorney McLaughlin, it might make sense that that happens first, and I comment on that subsequently, or I'll proceed however you'd like me to.
Does anyone have any questions for Attorney Ford?
I do, if I may,
Go ahead, Paul.
Mr. Chairman. Just to summarize, what I heard was, part of it was, there is no contamination existing now in the groundwater of the site.
Yes, per the Mass DEP, yeah.
And the studies that were done by the state or feds or whatever says that there's no contamination, measurable contamination from solar panels to pollute the site.
That's correct.
Thank you.
And just to follow up on the fire question, so, and going back to the PFAS, if the solar panels were on fire, how would they fight the fire? Do they use foam-based chemicals, or?
I mean, you would have to double check with the fire department.
Okay.
I mean, I think the whole issue of fire, Mr. Chairman, really related in the early stages when we were going through the process of getting an amendment to the overlay district enacted, the battery storage. And the battery storage resulted in a large number of inverters that had to be obtained on the site. And I'll get to it once you've had a chance for public comment, but public comment has come in that suggests that the plan that's before you is not accurate because it's unlike prior plans that TGA had that showed many inverters and a number of transformers, and now we're only showing 2 and showing 1 transformer, and somehow that's incorrect. Well, that's all a result of the town saying no battery storage. And so with that, it resulted in a total redesign of the site plan, reducing the number of inverters down to just 2 and reducing it down to 1 transformer. So most of the questions that we got with respect to fire, particularly as we move through the process at the planning board and then at the council on the rezoning, all related to the fire issue.
Go ahead, Paul.
In some of the, I'm sorry, in some of the letters we received in opposition talked about, 50,000 gallons of coolant, for instance, and the possible contamination, et cetera. That doesn't exist anymore.
No, it doesn't.
Okay,
It
thank you.
doesn't. No, none of that does.
Anybody else? Go ahead.
I just wanted a clarification on what Paul said about, or the answer to really what you said about contamination on site. It hasn't been tested on site. It's been tested adjacent on the town's water, or COM.
No, I think it's
water
been tested
property.
on site too.
Both, soil testing on site was completed,
Yeah.
and groundwater down gradient of the site was
I didn't see any
completed.
well locations, but I guess, okay, that answers my question.
Did we get any comment from Water on this?
They participated in, through the fire department, in site plan review, and we haven't received any comments.
I would have liked to have seen them here, just so we'd have their opinion one way or the other. And another thing, it just would have been nice if you didn't look behind you, these people that are, I think, abutters. It would have been nice if the information you gave us about, non-contamination and, what was it, what was changed? These changes that were made, how come these people weren't made aware of that? You could have really,
With all due respect,
avoided-
Mr. Bodenseek, all of those changes have been a matter of public record. They were all presented at the site plan review hearing. This is the same plan we presented at site plan review with one change. The fire department requests that the access road be doubled. This has all been a matter of public record for a long period of time.
Right, but communication goes a long way, is all I'm saying.
All right, so do we want to, I think we'll maybe hear from Attorney McLaughlin and then sort of proceed from there before you.
Okay, as long as I kind of reserve my right to maybe make a comment after that, I appreciate it, Mr. Chairman. Thank you.
Good evening, members of the board. Attorney Charles McLaughlin for the town. I submitted to you via email our opinion letter. I don't know whether you've all had a chance to review it. I'd be pleased to take a few minutes to read it into the record for the benefit of the public who probably have not seen it. Excuse me. It's addressed to the zoning board from myself regarding TGA Solar dated today. And I'll just read it literally and offer a few comments at the end of the reading. And I may shorten a couple of my comments here to keep this moving. But in any event, broadly speaking, the appeal requires a two-part analysis. First, General Laws, Chapter 48, Section 3, Paragraph 9th, commonly referred to as the Dover Amendment or part of the Dover Amendment, must be considered. Secondly, Section 240-8A3B of the Town Code, which is referred to here as the, quote, modification provision, unquote, must also be considered. With respect to the Dover Amendment, the Dover Amendment was originally enacted in 1950 in order to exempt religious, educational, and agricultural uses from zoning restrictions. Since then, numerous other exemptions have been added, including one enacted in 1985 for solar energy projects in paragraph 9th, which provides, quote, no zoning ordinance or bylaw shall prohibit or unreasonably regulate the installation of solar energy systems or the building of structures that facilitate the collection of solar energy, except when necessary to protect the public health, safety, and welfare. The solar exemption was recently analyzed, and I add for the first time, by the Supreme Judicial Court in 2022 in the case of Tracer Lane 2 Realty LLC versus City of Waltham. The solar developer in that case had proposed to build a roadway in residentially zoned Waltham to service a solar array that was immediately adjoining in Lexington. I just note, although I don't mention this in the letter, that the parties agreed and the Supreme Judicial Court ruled that the roadway was an integral part of the solar array and hence had the benefit of Chapter 48, Section 3. In any event, that's important because the relief being sought in the case was based on Chapter 48, Section 3. The roadway's purpose, I should also add, was physically to gain access both for fire and for servicing and maintenance and replacement and the like. So very much in the, as COM has required a widening of the road here, so too was a roadway going to be necessary in Waltham. The Supreme Judicial Court determined that since only 2% of Waltham's land area was zoned for such a project, the limitation effectively prohibited such projects and violated the clear legislative intent expressed in Chapter 48, Section 3, to promote alternative energy to combat global warming. The court stated, quote, standalone, large-scale systems, not ancillary to residential or commercial use, are key to promoting solar energy in the Commonwealth. See Executive Office of Energy and Environmental Affairs, Massachusetts 2050 Decarbonization Roadmap, and the site is given. And they quote from it, quote, "The amount of solar power needed by 2050 exceeds the full technical potential of the Commonwealth for rooftop solar," indicating that substantial deployment of ground-mounted solar is needed under any circumstance in order to achieve net zero greenhouse gas emissions by 2050. The court goes on, "Nothing in the record in that case suggests that this stringent limitation is necessary to protect public health, safety, or welfare." And by the stringent limitation, they were referring to the 2% of land area committed to solar. The court goes on, "Where Waltham has prohibited solar energy systems like the one here in all but 1 to 2% of its land area, its zoning code violates the solar energy provision." And I just note of the Dover Amendment. Thus, the question under the Dover Amendment and before the ZBA is whether the sideline setback here is necessary to protect health, safety, and welfare. Those being the very important words that appear in 40A3. I just note that this is an exception. Most of 40A3 lets municipalities examine bulk issues, sideline setback, height, size of the building, et cetera, et cetera. And in fact, there was a fight about, I believe, a daycare center back in the early 50s that prompted the enactment of the Dover Amendment. But in any event, this particular part of 40A3 under paragraph 9th substantially expands and recognizes the town's interest and ability to consider matters of public health, safety, and welfare. And that exception is really a one-off in otherwise, as worded in 40A3. You won't find that anyplace else. With that editorial aside, let me move on. Addressing the modification provision, Section 240A3 of the Town Code provides, under exempt uses, subsection A, the following uses and structures are permitted in all zoning districts. Under Section 3, it says the use of land or structures exempt from the use provisions of this chapter pursuant to Chapter 40A3 and any other statute. And then sub A under that, where such exempt uses are subject to reasonable regulation of bulk density and parking regulations by Mass General Laws 40A3, reasonable regulation shall be deemed to be the bulk regulations of the zoning district. Subparagraph B then goes on, where the proposed use does not comply with subsection A3A above, that which I just read, the Zoning Board of Appeals shall by modification permit modify the bulk regulations of the zoning district where such regulation would substantially diminish or detract from the usefulness of a proposed development, or impair the character of the development so as to affect its intended use, provided that the modification of the bulk regulations will not create a public safety hazard along the adjacent roadways and will not create a nuisance to other surrounding properties such that it will impair the use of these properties. And then in subsection paragraph C, a modification, a procedural observation for this board, a modification permit shall be subject to the same procedural requirements as a special permit, except that approval of the modification permit shall require a majority of the members of this board. So you'll need three members to vote in favor of this in order for it to be granted. It's not a supermajority, just a regular majority. but it is 3 members of the board. If you have only 4 participating, you're still going to need 3. On to section 3 of my comments, and I'll be able to wind up shortly. And this is questions required to analyze the pending petition. TJA Solar asked for a modification permit to allow the solar array to intrude 84 feet into the required 100-foot setback on the westerly side of the lot. TJA argues in part that this relief will enable it to maintain the required 175-foot setback on the easterly side of the lot. The developer alleges that being required to observe the westerly setback, 100-foot setback, would reduce the size of the array by about 25%. You've heard further comment on that today, and I'll defer to Attorney Ford on the differing figures if they need further explanation. Having in mind that the town-owned lot abutting the westerly side of the site is dedicated in perpetuity to water conservation, and that the town lot will never be developed, the board should determine whether maintaining the 100-foot setback is necessary to protect public health, safety, and welfare. The board should also determine here whether requiring the developer to maintain a 100-foot setback from the sideline would, in the words of the modification provision, our ordinance, quote, substantially diminish or detract from the usefulness of a proposed development or impair the character of the development so as to affect its intended use, unquote. If the answer to that question is yes, then the modification provision requires that the board shall by modification permit modify the bulk regulations of the zoning district to accommodate the proposed project, unquote, provided that the last analysis discussed immediately below is undertaken. And then I note that finally the board should also determine whether the proposed extent of modification would, again in the words of our ordinance, create a public safety hazard along adjacent roadways or create a nuisance to other surrounding properties such that it will impair the use of these properties, unquote. If the answer to this latter question is in the negative, the modification provision appears to mandate that the requested modification be approved. If, on the other hand, the answer is affirmative, based on specific findings of this board, then the modification could be denied or modified to a point where modification would no longer create a public safety hazard along adjacent roadways or otherwise create a nuisance for surrounding properties such that it will impair the use of these properties. I would ask you, I didn't want to make this, given the time that it would take to do so, a longer than necessary observation about the context that we find ourselves in, and I'm happy to answer any questions that either the board or public may have on the litigation status. But I do want to make note, importantly, that with the benefit of some of at least the Supreme Judicial Court's comments in the Trace Lane case, it's instructive, and so I've offered this concluding paragraph to you. While considering these questions, please be aware of the strong public policy considerations expressed in the Dover Amendment that favor as-of-right siting for solar, and the Supreme Judicial Court's decision in the Trace Lane case that decisions to deny the requested relief under local zoning ordinances must have strong fact-based findings that the project would pose undue risk to public health, safety, or welfare. Please also closely consider the analysis required by Chapter 240, Section 8 of our ordinance, and the need to make detailed findings to support your answers to the questions posed by the modification provision. I say that the only comment that I'll offer in context is that what was abundantly obvious after reading Tracer Lane is that pro or con, depending which way the board decides to go, either supporting or opposing this project, we need good, solid findings in that respect. It's not healthy and probably not procedurally likely to produce a defensible result if challenged if we don't have good findings. So I'm happy to answer any questions along the way, but I really appreciate your time. Thank you.
Thank you, Attorney McLaughlin. Does anyone from the board have questions specifically for Attorney McLaughlin?
Perhaps I could ask just one. It's more of a general question. I'm sorry to pull you up there. Just very quickly, I've heard the term used when speaking more often about water quality, but to protect public health, safety, and welfare as a general term, I get the first two, but maybe for everybody else here, is there general terminology for welfare within this context?
It is not further defined in the state statute, and the Supreme Judicial Court, interpreting this statute for the first time ever, at least at the appellate level, did not choose to spend much time, if any, on the question of welfare. We have wrestled with the question, and welfare is a term that in public health, safety, and welfare is a phrase you see repeatedly in case law in other contexts, but also but particularly arising out of a zoning matter. And welfare, I think, is perceived to be a catch-all that is intended to protect the best interests of the town and its populace. And what specific items are included in welfare, public welfare, safety, obviously, as you note, is easy to point out. Health is safety to point out. Welfare seems to be the catch-all, and as an extreme example of something that might adversely affect welfare, a tall building or structure that might block out a home's sunshine, et cetera, might well be something that would be adversely affecting welfare. It might also affect health and safety, but it might be just one example. But rather than try and get into detailed speculation in this case, I don't think it's helpful. But it is a catch-all, and it does have meaning. You do see the courts refer to it all the time, and I think it's a broad example of something where the legislature intended to be fact and site specific with respect to a particular project and how it might affect the neighborhood. I don't know. Cape and Vineyard Electric did a solar project down next to Dennis Yarmouth High School, and we got a lot of feedback in terms of whether it be health or safety, but also welfare, fencing off a large section of ground that was needed to support the project and protect the public from exposure, accidental exposure and contact with the electrical elements. But there was also a welfare argument in that case about the fact that we were taking playground or recreational open space away by fencing it in. So that might be an example where you might consider something like that.
Okay, thank you very much.
I hope it's
Attorney
helpful.
McLaughlin, question for you. What percentage of our land area in the town is zoned for solar?
That is a open item for litigation, which was raised in the original suit, and we certainly have one of the larger towns in the Commonwealth. There is a suggestion in the pleadings filed by TJA and the land court that we are down around that 2% level. I haven't looked at that complaint for a bit, but I think I'm safe in remembering that it's the allegations were approximately down in that range, which to me is a very unhelpful analysis, and I'm surprised that the Supreme Judicial Court relied I don't know whether everyone agreed in that case, in the Trace Lane case, but in our case, we asked GIS to go in and evaluate what properties in town are truly capable of development that aren't already impressed with structures, roadways, water courses, which obviously make up the gross area of the town, and such things as restrictive covenants, conservation restrictions, et cetera. And when we got through doing that extensive GIS analysis, our conclusion was that the allegation that we're down around 2% was not at all accurate. We thought we were much closer to, and again, I hope I'm being accurate in my memory, saying it was 6 to 8% of the available, technically available area in the town could be developed for solar. In terms of large ground-mounted solar, and I do remember one other sieve we put this through, an acre of, 5 acres approximately of solar when we were doing the Cape and Vineyard projects equates to about 1 megawatt. And so this ordinance speaks to large-scale ground-mounted being something 250 kilowatts or larger. And so you're going to need, between access and fire access and service access and other setbacks, et cetera, you're going to need, at least for that first megawatt of electricity, you're going to probably need 4 to 5. For a 250 kilowatts, you're going to need an acre and a half or 2 acres probably to do it. And I'm sure that the engineers can pick me apart, and they should, and if it was relevant. But at the end of the day, when you put that sieve together, a very significant portion of our available land that meets those criteria to support large ground-mounted is we utilized, having in mind what we've already deployed around town. We do have a lot of solar on the ground, and percentage-wise, I don't want to guess any further, but we were multiple times, in our view, higher in terms of the available land, our compliance, I should say, with deployment in terms of available land. We've used a big chunk of our available land in that criteria sieve to bring these solar projects to fruition. So.
And then in the Tracer Lane case, was that project could not have been built without the road, or would it have been smaller?
I didn't see in the factual development that it was addressed in that term. What they needed, whatever the configuration was on the or the topography or other elements that would limit ground access from the Lexington side, the developer determined that bringing the roadway in through a residential zone in Waltham and connecting right over the immediately adjacent town line into the solar system, the solar array, was what they were looking for. And I think reading the case, I don't know whether Mike would remember it differently, but my impression was that this was probably the only access, the only viable access to get to the solar array. And so it wasn't so much a question of reducing the footage. It was either you can get to it or you can't. And if you can't, or if that roadway wasn't available, I'm not sure the project would have been able to go forward, but I'm speculating. Okay. It was not the focus of the SJC's decision.
And then just to the Dover amendment, I mean, our zoning's not restricting the use in this situation. We just have a bulk regulation issue, correct?
It's a chicken and the egg analysis under the Tracer decision. outcome, I think it's important to say the outcome of the Trace Lane was that basically the default provision of the Commonwealth and of the intent of the Dover amendment is to allow solar to be developed without restriction, except for considerations of public health, safety, and welfare. So I'm ducking a question to a certain degree, but I think the important point that the court wanted to emphasize, and particularly in light of all of the debate and not debate, but the response that the Commonwealth is attempting to provide to mitigate greenhouse gas emissions, is driven in no small part by alternative energy production options and the role that solar will play in that. So I emphasize that in any fight that we have on this that might arguably deny the project because of rulings, it will be attacked on that basis that we're effectively denying. And if it's a good decision based on health, safety, and welfare, we'll defend it fully. But we do have an uphill battle at the legislature, given the legislative pronouncements and given the administration's pronouncements, as endorsed by the Supreme Judicial Court. Very similar fact situation. In fact, that the case against the town was filed within a very short period of time after the lower court decision in Tracer from the land court issued and announced these same considerations. So,
And then one last question. How did we create our bulk regulations for solar? Is that pretty standard? Is the 100-foot standard? Like, what was sort of the history there of how we got to 100 feet as being necessary setback?
We started with we initially enacted the solar overlay district in 2009, I believe. And it's utilized for limited areas, primarily the industrial areas of the town, and until this case came up. And we recognized that we were going to have to look at other areas, perhaps to at least do the good faith analysis to figure out where we could support without undue negative impacts, large-scale, industrial-scale, ground-mounted solar. At the end of that process, I think the important consideration is that we had very extensive, frank, and candid discussions with the Developers Council, who's here tonight, Mike Ford, and in terms of what middle ground there might be. We wanted to create a public process. We wanted to, with input and concerns expressed by the neighbors, wanted to make sure that we were all satisfied that with fire risk, et cetera, that we had a reasonable set-off from it. The exact numbers here came in by way of an amendment from one of the councilors during the debate in front of the town council, and the main motion to approve was amended and added these footage amounts to a higher level. Jim, I'll ask Jim Cupfer to tell me if my memory's wrong, but to increase the offsets in residential zones, et cetera. So that's the history of how those numbers came about.
Okay. And do we know, maybe Jim can answer, is that sort of, are these numbers standard? Are we generally higher than other municipalities in the Commonwealth?
May I ask the author of most of these and let him field that question?
Oh, I have a question first. Oh, you're going to come back?
I'm sorry.
No, it's okay. We're in mid-question here, so.
Good evening, everybody. Jim Kupfer, Senior Planner, Planning and Development. Yes, so the amendment to our zoning ordinance took about 6 to 7 months of research and development through the planning board process. We utilized the Cape Cod Commission's guidance in terms of large ground-mounted solar, as well as researching other best practices throughout the country and actually some internationally. New York State actually kind of leads the charge in terms of best practices, and so we pulled a lot of their ordinance into what you see here tonight. The setbacks specifically do pull from New York, as well as the Cape Cod Commission recommendation of a 100-foot setback. In addition, as Attorney McLaughlin mentioned, there was further amendments on town council floor to further that 100-foot to 150 on the residential side. So that 100-foot came from, best practices essentially throughout the country and specifically here in our area.
Now, were these discussions after or before the lawsuit with TJA?
So
Kind of my question is, did we see a modification permit coming when all of these discussions were taking place? Or am I just being naive that it should have been all hammered down in the first? It sounds kind of complicated, but.
Right. I'll let Attorney McLaughlin speak to that. I operated through the planning board process, so I'll leave that to Attorney McLaughlin.
Thank you.
The modification provision was, and for those of you who had the pleasure of knowing Bob Smith, we think it was Bob. It certainly has his fingerprints all over it. They were looking for a way to address as of right placement and still try and find some modicum of control over it, particularly where health, safety, and welfare issues might, and bulk regulation issues might arise. And so whether it was Bob or then the small planning staff we had or some combination, this was enacted 1988, I think, 89, somewhere in that range. And I'd have to pull it to refresh myself. But again, it goes back that far. And so it was on the books. I candidly had not come across that in any of my work over the years. And I believe it was brought to Mike Ford's attention and brought it forward. I think it is a good piece of legislation that was, again, well predates solar, quite frankly, and recognized the delicacy of dealing with trying to set some standard as to what bulk regulations might address. And it, as you can read, it would suggest that the council then was satisfied that if you had bulk regulations in place that were relevant to the project in front of you, that the bulk regulations would be deemed to be reasonable under 40A3, and a pronouncement from the town that we believe that those bulk regulations were reasonable regulations to consider a project and apply to a project. So I think that's is probably, I'm not sure whether I've answered your question, but that's the history and the interaction of it at this point. It's been on the books for a long time. No one, I think Mike was able to find one other project that might have predated a project he got involved in years ago that was able to successfully utilize that section, but it's obviously not a commonplace section to go looking. So
I think we had a modification permit here recently, but my question really was the planning and back and forth with the town council and everything else in the lawsuit that resulted in this zoning district. Was that foreseeing that this would probably end up in front of zoning eventually, or was it?
I don't know. We did not get in. We weren't. That whole planning process was done in a very generic fashion without reference to TJA. So,
Or the specific site?
I'm sorry?
Or the specific site?
The
there?
specific site. In fairness, the specific site that was rezoned to as of right was site-specific, but that's, unless anyone cares to correct me, that is my recollection of what the degree of specificity related to this site was expanding the overlay district to include this extra acreage, period. We did not get into, nor should we have, in my view, at that point during the planning process and the legislative process, to site-specific considerations. We were aware of concerns of neighbors that were well-placed, and a lot of colloquy on that at the staff level with neighbors and through councilors. So, and some of those provisions found their way into into the revised ordinance. I do say that as you're considering the risks, we put a lot of time into getting some good feedback and some good protections in there. If this goes up on appeal and the town were to lose its position on this, it's unclear whether whether a court would look at just the setback or blow up the entire ordinance and leave us without the protections that we worked for almost a year to enact. So that's no reason to go one direction or another, but it does emphasize my concern. Whatever decision you make, I certainly would love to see it well thought out and as you will, but well documented for the reasoning. So
I'd just like to see everybody happy. TJA, the owner of the land at 810, and the abutters, everybody, it should be possible to make everybody happy between vegetated buffers and, if I can be convinced that the town water supply isn't in peril, things like that.
There are something that we have learned in my office, and particularly my involvement with both Cape and Vineyard and Electric, with NSTAR in terms of transformer expansion activities all over town, and with regard to Vineyard Wind and now Park City Wind, where we have put in place what we think I'm safe in saying state-of-the-art water protections in place. Full disclosure required with regard to any hazardous materials. And I'm sure if this gets back to the planning board for them to go through their process, that these exact questions will come up as they should, because it's part of the analytical component to determine whether or not the project, in whatever size and configuration, has met all of the standards, pages of standards that are pretty tough. And water, certainly from my perspective, water preservation and quality is very high on the list. You may have heard me say in other contexts that there are very real risks to these cooling fluids, and I don't like, with great respect to Atlantic, I don't like hearing someone say, well, it's like vegetable oil. Well, as Dan Santos said to me once during a Cape Wind hearing, you can drown in too much milk, but anything oil-based falls under our the mass contingency plan, which is the DEP list of chemicals, either generic or by brand name or otherwise, that you do not want getting into your water quality. And any oil-based product pretty much falls into that category that you don't want in your drinking water. And the allowable content under the of oil-based products in drinking water is at a ratio of 1 gallon per 5 million gallons. So everyone says, well, there's only a chance of a small leak and we're only going to drop 5 or 10 gallons. We go back to, and I'm sorry to get off at length on this tangent,
I think
it's
we're
important.
off here. The Board of Health has had a shot at this, right?
Board of Health is considering it.
Right? Okay, well, then I think that's where this aptly I mean, rather than a personal opinion, I think the Board of Health is the one that's the qualified.
Board of Health certainly is, but it is part of the analysis that, in terms of water quality, that particularly the planning board, if it gets this case back.
Right, but neither you or I are an expert on whether vegetable oil is or isn't pollutable to the water
I
supply.
couldn't agree more.
So
That's-
can we move on then? Get off
I'm
this
trying to
point?
answer fully the question, but thank you, Mr.
I just want to
Benoit.
go
I would
back
like you
to
to
Herb's
And I appreciate it.
question.
Thank you.
Hold on, I just want to go back to Herb's issue. Just to clarify, the zoning regulations that were created for solar voltaic are uniform. The bulk regulations are not specific to this site, correct?
Depending on which bulk regulations you're,
I mean, they were not created based on this site. Or were they created for this site specifically?
That's what I understand.
they were created for this site, for the overlay district, not
For the
just
overlay
this site.
district, not this specific parcel.
That's a fair comment, I think. It applies to the amended zoning overlay district and throughout, wherever those parcels are throughout the town. So it's not just Marston's Mills, not just this site, it's anywhere that we have the overlay, solar overlay district in place, these apply.
Okay, so could it be said that the towns kind of benefited from all this in coming up with a,
Oh, I think everyone who participated recognizes that what we accomplished was well worthwhile. It may not be everything that some folks want, but what we did accomplish goes significantly improving safety factors with disclosure and design standards that will be in place to protect against products that could be hazardous and could leak, so, and other considerations as well, so.
yeah, my big fear is that commercial interests write their own rules, and I think we need to avoid that. But we also need to, the Dover decision, sort of,
Well, let's save that for discussion,
Yes.
just deliberation. All right, so let's go, if Attorney Ford wants to sort of respond to the memo from Attorney McLaughlin and any of the other comments.
If I could, thank you, Mr. Chairman, members of the commission. So let me start here. First of all, I don't think the 2% has anything to do with this case, with all due respect. That's not the issue here. I understand why Attorney McLaughlin advised you of that case, and it was to show you the strong support that large-scale solar array has, not only in the legislation in Massachusetts, but also in a decision of the highest court of the Commonwealth. I think that's the reason that that case is important to lead off with, not the 2%. The dimensional requirements in the new amended overlay district, here's what they are. Ground-mounted solar voltaic installations are subject to front, side, and rear yard setbacks as set forth in the underlying zoning district. That's 15 feet. Except that any ground-mounted large-scale solar photovoltaic installation with 250 kilowatts or larger located in a residential zoning district shall maintain a minimum of 150 feet to residentially developed lots and 100 feet to the other property lines to contain noise. That's the reason put forth in the bylaw. That was the reason for the increased setback. Noise, that's what it says. So in our case, we had a plan that had 8,900. We did not agree with these setback numbers. We expressed our concern when this was going on. We have availed ourselves as a result of these numbers of a provision in the bylaw that existed, which is the modification provision. And I think if you go back to the only thing we have, which is what the bylaw says, that the reason for these increased setbacks was to contain noise, then what we're seeking is to go back to the underlying zoning district, 15 feet, on the westerly side, where there's an open space parcel where noise is not an issue, even if there was noise. And the last time I checked, solar arrays do not make noise. But to the extent that they do, that side, there is no reason for a setback of 100 feet. based on the language of the ordinance itself. On the other side, we took our proposal and moved it all the way to the west to get away from those people that were concerned about the noise, and we remain 150 feet off, except now that the fire department has asked us to increase this access road from 12 feet to 20 feet. And that gets us into that side a little bit. Because if you read the ordinance, it sounds like what they wanted was not only the arrays 150 feet, but also the access road. And so we've included that in our modification request. So when you say what are customary and what are best practices, Cape Cod Commission best practice from a developed lot is 100 feet. That's the largest I've seen in any ordinance that I've looked at. Now, there may be some in New York. I defer to Jim. I didn't look at New York. But that was for a developed lot, Cape Cod Commission. Again, we're seeking the modification on the side that's undeveloped and on a piece that's restricted, never to be developed. And so I fail to see what the, not that anybody's argued it yet, but I would suggest to you there's really nothing in this record that would suggest that coming to the west, where we would like to be, is something that will create a public safety, a public hazard, or be detrimental to the public welfare. Based on the language of the ordinance, that this was all about noise. That's what it was about. That's what it says. And that's section 240, 44.2, E, 3, dimensional requirements. So I think it's important to focus on what's really before you. And the 2% rule's not before you. What's before you is this plan. And what I would like to do, Mr. Chairman, is just briefly walk through, because I think Attorney McLaughlin properly laid out what the path is for you to make your determinations on our request. And it's a three-pronged test. And the first is, if we don't get the modification, is there a substantial diminishment of the solar array? Okay, again, just to review. We had a plan. We were initially talking to the town about 75-foot setbacks. We had looked at a lot of best practices, the setbacks in the bylaw, when we started talking to the town, and they encouraged us to come forward through the Infrastructure and Energy Committee. The setbacks were 15 feet because it was the underlying district. That's what the old bylaw said. It continues to say that, except for residential in this piece. So we had 12,000 panels. When the increased setbacks came in, we went down to 8,900 and took it and pushed it to the east, knowing that we'd have to request a modification from this board. But thinking that, based on noise, we would be able to pass that test. So we went from 12,000 to 8,900. If we don't get this modification with the reduced setback to the west and the fire road, we lose another 3,000. I don't think there's any way that you can't find, frankly, that would be a substantial diminishment of this solar array in terms of the energy production that it's going to put out. And we all know what the Supreme Court said about everybody's trying to meet that goal of 2050, and we're not going to get there without ground-mounted solar array systems. So I think on the first question, you can answer yes, that there would be a substantial diminishment of this solar array if the requested setback relief is not granted by way of the modification permit. Second test. If you grant the modification relief, in other words, the reduced setback, will it result in public health, safety, or welfare problems? Again, I'd suggest there's nothing in the record to show that that would result. Why? This increased setback, according to the language of the ordinance, was for noise. We're getting closer where there's a parcel that in perpetuity will be open space and watershed protection. I don't think you can make the finding, frankly, that, at least on the record that you have at the moment, that there's a public health, safety, or welfare problem that results, and this is what it has to result from, the granting of the modification from the 100 feet next to the undeveloped piece to the 15 feet. I could see it if this piece might be developed in the future, but it's not. It's permanently restricted, not only in its deed, but it has a conservation restriction on it as well, held by a water company and a land trust. So I'd suggest you can answer no there. So yes, no. Third prong. You got to make a finding that there will not be undue nuisance or congestion along the adjacent roadways, not as a result of the project, as a result of granting the modification. So I would ask you, how does granting the reduced setback result in hazard along adjacent roadways? I could see if this exempt use was a school, and the school was going to get bigger, and it was going to have more traffic, and you might say, well, if we give you this modification request, you're going to have 25% more buildings and more kids, and I can see the relationship there, but I don't see it with this one. There is no traffic. And there is no wastewater, which is the beauty of this use, because we got a watershed protection piece next to us. That's critical. There's no wastewater with this, no septic system whatsoever. So I think you can make the finding there that there won't be any such nuisance. And finally, it will not create a nuisance to other surrounding properties such that it will impair the use of those properties. We're seeking the setback waiver, except the access road, on the westerly side where there are no houses, where there should not be a noise issue. So, and to the extent that the access road is in the 150 feet on this side, and the planning board can't waive it in their special permit, which they might be able to do, but we've asked you to consider that for relief in case they decide they can't. I don't see where the use of that fire access road intermittently increased at the request of the fire department for a public safety reason, in his view, to make sure that the fire chief thought he had sufficient access, is going to result in a nuisance to the developed properties on that side. I don't see it. Those are the three things you have to decide. Not whether there's 2% or there isn't. Town's already made a decision to rezone this. We got to get a special permit from the planning board, and we need this modification permit from you. And your part in this is fairly narrow. It's just the modification part. So those would be my comments on that, Mr. Chairman. I don't want to take more time than, if you have questions, I'd be happy to try and answer them.
All right, thank you. Does anyone from the board have any questions for Attorney Ford?
I have one really dumb question. The pink, is that the access road?
The pink on the right-hand side is the access road. On the left-hand side is the array where we're seeking the waiver. So all of the pink area is waiver requested.
Okay. So to the east of the pink on the right-hand side?
Yes.
That is still the 150 feet, or is that 150 minus?
Minus
12
the
or
access road.
20?
So it's not within the, is the security fence going around the access road?
Yes.
Okay. So our site's 19 acres. The fenced-in area where the array is approximately 10, a little bit more than 10, maybe 10.3. So 9 acres is buffer zone of the 19 acres. And on that side, it's at least 140 to the access road at all spots, if not more. The other thing that we have
Versus 150.
versus 150. For the supposed reason in the ordinance, I won't say supposed because it's there, for noise. That's what the ordinance said. That was their concern.
And then, so it just came up that the fence will be adjacent to the
It'll fence in the access road.
access road?
Yeah,
So
everything is fenced in. There's a security fence around the whole thing.
How about the wooded area or whatever it ends up being, the vegetated area? That is not fenced?
It's not,
Oh, okay.
no.
That sounds kind of good.
Yeah, it's not,
And then animals and such could still get
Right,
in and out. People
right.
could walk their dogs. There won't be like no trespassing signs everywhere.
I have no idea. I can't represent to you, there will be no trespass, no, I can't represent that.
All right, so if there's no more questions for either Jim or Attorney McLaughlin, do you have anything to add or anything? Okay. All right, so we'll open for public comment. I just want to urge the public to be specific to what's before us. It's very specific to the setbacks in this situation and the way the bylaw is written for us to approve or deny this. So I just want to keep everyone very specific. If anyone would like to come speak to the podium, just introduce yourself with your name and address.
Hi, my name is Steve Okolowitz. I'm in a butter, live right in the neighborhood, right next door to this. 3 minutes?
Could you state your actual address?
Oh, 26 Dove Lane, Marston's Mills.
Thank you.
Fires at the solar farms are severely underreported. The greatest, most common risk of these are faulty equipment, poor design and installation, a lack of frequent third-party inspections, and the weather. I think to allow Atlantic Design to certify their own project, is a dangerous mistake. This kind of project needs the oversight of other knowledgeable engineers. TJA's emergency plan, I think, is a joke. It's relying on anybody noticing a fire, since there's only, from what I understand, planned 2 visits a year. It's the responsibility of the abutters to see the fire. TJA's emergency plan says only a member of the management is authorized to speak on TJA's clean energy behalf to the police or fire department in the event of an emergency. Imagine that. Are the abutters authorized to be able to even call 911 if there's a fire? So from what I understand, the emergency contacts both live in New Bedford, which I don't understand the whole fire plan. How will they show up to shut down the equipment before the fire department can even begin? There's no mention of any kind of alarm systems for the people living around the neighborhood.
Steve, I just want to coach you here, is that that's not our purview of the zoning board.
Okay, we'll get back to the setback.
I mean, have a little respect. He's talking about public safety here. This is safety. That is very clearly one of the criteria here.
Only as it pertains to the modification permit. Only as it pertains to the modification permit. That's the issue before us, not the whole solar array.
The board has to determine whether maintaining the 100-foot setback is necessary to protect public health, safety, and welfare. I would consider a fire a safety and welfare
The
issue.
road doesn't have anything to do with calling who reports any of that stuff. It's access, that's in our purview, but the rest of it is not.
I mean, I think we need to let the public speak.
Okay. I'm halfway through. Halfway through my 3 minutes. Well, I am concerned if the southwesterly winds, the area that they're reducing, from my orientation, that's on the southwest side. I also think that the setback also acts as a fire break. What if a brush fire comes from the southwest side and we're only looking at 15 feet or 20 feet on that whole side there? I'm really concerned about fire issues and about the hazardous materials. I lost my place now, but if the hazardous materials are spilled, and from what I understand, the TJA's letter assures that there's no hazardous materials on the site, but they make a reference to the hazardous materials being spilled in excess of reportable limits. I lost my place. But the limited liability company is playing with the lives of all the abutters and all the neighbors around in the whole area, all the way around this. I don't think they can be responsible for the damage or the loss of our homes and our lives and our property. I don't think there's any good reason to even consider allowing this project. The legal setbacks, getting back to the point of the legal setbacks, there are already almost no protection against this kind of fire. And if we reduce them on that side, I'm even worried about fire coming from the southwest side there. And then also any potential pollutants getting into the water area there. So I've got a lot of concerns about this. Thank you.
Thank you very much. Yep, come on up.
Hi, my name's Mary Birkinshaw. I live at 133 Mockingbird Lane. I've lived in the mill since I've been a property owner since 1984. I've been at this property since 1994, so I've experienced everything that's gone on, from the mining operation that was going on to the clear cutting to the Supreme Court ruling about no trees to be removed. All of that, I've been part of it. This morning, I turned the news on, and I saw this disaster in Indiana. And one of the things that they were saying during the news conference was that that property that was burning, I mean, it's not a solar property or anything, it was a recycling plant or something, but had numerous issues through the years, ignored court orders, that sort of thing. And I felt this feels very familiar to me. And when I started thinking about, I've lived on this property since 1994. There's been numerous brush fires out there. It used to be the woods, there'd be fires. One time there was, the brush breaker came in right behind my house, there was a big fire. There's been lots of brush fires out there through the years, especially where it's getting, the droughts, it's dry in the summer. It's a tinderbox out there. So I understand that TJA is a company and they want to make the most money for what, they can at any given property. I understand all of that. But the point I'm trying to make is that if, say there's an accidental fire, a spark, something, plan for the worst, hope for the best. If a fire starts, and maybe it's only a few solar panels that get ruined or whatever, maybe it's able to be contained, the fire department's going to have to come out. They're going to have to spray whatever it is that they spray on electrical fires. This is on top of a watershed next to a conservation area, next to people. What happens if there's a big fire and these billowing smoke? Do we get evacuated? Is it safe? Is that smoke safe? I'll tell you, I've lived there, and in the summer I've had my windows open when the activity is going on out back. My counters are covered with dirt. I have to keep my windows closed when the trucks are coming and going out of there. So if there is, like was said earlier, if there's a fire and it's blowing, it's going to blow right into my house. I mean, I'm probably the closest to my house to the lot line. There are houses, neighbors have babies. There are people who are, limited mobility.
3 minutes, we just wrap it up.
Oh, I'm sorry.
No, keep going.
But I'm just very concerned that there's no provisions for us. There's a lot of provisions to protect assets and to protect the property and the watershed and the conservation. But what about the people? What about us and the babies that live up the street? That if there's a fire behind their house, and by the time, I don't know. I just, after seeing that this morning, I just was very concerned.
Thank you very much.
Thank you for your time.
Christine McDonough, 111 Mockingbird Lane. Jim and I and the family have lived there for 40 years, and out of those 40 years, we've spent 30 years dealing with the town and a neighboring property that has had illegal uses, and we've had enough. From my kitchen window and my back deck, I can see clear across the pit, and I can see out to Wakeby Road. I can see the cars going by. There is no fence or berm high enough, I don't think, that will block the noise or the glare from those solar panels on my property. Unfortunately, having the right to preserve this quiet enjoyment that we're entitled to, supposedly, in the town of Barnstable, it's become a generational issue. My kids are quite upset as well. We think enough is enough. I hope you keep our health, safety, and welfare in your hearts and minds, and do the right thing and say no. Thank you.
Thank you, Ms. McDonough.
Catherine McDonough, also at 111 Mockingbird Lane. When the town council was voting on whether or not to include 810 Wakeby in their solar overlay map, it seemed the only way to prevent this monstrosity of a project from going through was to vote against it. But our board members assured us that the solar overlay ordinance would protect us. We were devastated when the vote did not go as we abutters had hoped, but took immense comfort in the fact that our diligent planning board and town planners had heard and understood our reasons for not wanting to live behind a massive, buzzing, toxic, potentially explosive solar megalopolis, and decided on very reasonable, undisturbed 100 to 150-foot setbacks. Like, okay, if this reckless landowner and his dishonest cronies from TJA eventually do get their way, despite the tumultuous, contentious, illegal, and extremely expensive past that cost my parents, our good neighbors, and our town dearly for over a decade, at least it'll be 150 feet away from us and our water supply, and that setback will remain undisturbed in perpetuity and free from all motorized vehicles. Maybe it won't be that bad. No more strangers driving trucks and machinery along our lot lines. No more landowners filming us from high atop heavy excavating machinery after deforesting their property yet again. No more dirt bikes and four-wheelers kicking up dust and spewing exhaust to the point that we have to close our windows, as Mary said. No more large commercial vehicles driving in and out of the property and banging every single morning and night. No more false claims to grandfathered uses that the town has been remiss in its duty to shut down despite court rulings, but no, now they want to take that too. This ludicrous proposal could not only jeopardize our aquifer, but also the distance from this hazardous eyesore that we were guaranteed by the original solar ordinance. The ordinance net is now the only thing that stands between us and a miserable future next to a gargantuan commercial operation in a historically residentially zoned neighborhood. It's appalling that this company is continuing to strong-arm our town into bending over backwards for their financial gain, as is their history of suing other towns' board members and being dismissed with prejudice. Rather than proposing to build these very useful arrays in a more appropriate location, they sued us and were granted the change in zoning. But it still isn't enough. And if these change in setbacks are allowed to pass and they're given another inch, there's no telling how many more miles they're going to want to take from us next. Growing up next to barbed wire and illegal mining operations was horrific. I watched my parents fight with this town and for our village, and for our neighborhood and our neighbors, and for our home and our family. And never could I have imagined that decades later, this town would consider allowing their struggle to become my fate and the fate of my children. We implore you to not let this happen to us again, and to simply uphold the amendment that our town planners worked so hard to develop. I know you all need hard data to defend your decision, but how do you measure decades of stress and worry and upset? The reasonable parameters, best practices, and safeguards in the solar overlay ordinance can only protect us if they are prevented from being circumvented by this modification permit. We thank you in advance for standing up for us and not allowing this landowner to profit off of a history of illegal actions as ruled by superior and supreme judicial courts and bully our town into yet another bad deal that will only benefit those farthest from it. I sincerely appreciate your time.
Thank you, Ms. McDonough. Does anyone else want to speak?
Hello, my name's Ryan Militia. I'm at 23 Doves Lane. I'm probably the newest member to the great neighborhood that we're part of. I kind of have a couple questions and then piggybacks to things that some people have said. The purpose of the watershed property is interesting because it almost is just it kind of guarantees that we have obviously safe groundwater, and I guess every property is supposed to do that. And I understand they're, making sure there's no leakage with what they're doing, but it's kind of, I think it's almost impossible to say that you're not going to have contamination with this type of project. There is, as far as I can tell, there's currently wetlands abutting the property, and that's one of the things I was kind of confused at, how this could even happen so close to a wetlands property with the species that are in that property, but I could be wrong. The buffers seem to only help for seasonal view because everything kind of dies other than like an arborvitae type thing. The COM represent, like Herb was asking, I don't know why they haven't been here, but I would request that they show up because they're the ones that are going to try and fight the fire. I mean, we all know, you've seen the electric car fires. Really, any electric fire, you don't fight it, you just let it burn out, because if you spray anything on it, it's going to create more of a problem. It's not going to just stop the fire. I was wondering what the secondary fluids are. I know that the first fluid was vegetable oil, and that's great, but obviously, as Attorney McLaughlin mentioned, it's still an oil, so it's kind of, it doesn't make it any better. There's no direct advantage for any of the butters or really anybody other than the people that are profiting from it. And I get it, I understand too, it's a corporation, you gotta make money, but there are healthy ways to do that. And it seems that TJA has a history of bulldozing, there's no pun intended, their way through these types of projects with, of course, the money that they have to do that. It's funny that I'll ask this, but is the town inspecting the whole entire project, or is it waived because of an engineering, if it's an engineered electrical plan, is it being inspected by the town to make sure that it's having a second set of eyes on the electrical portion of it? And I don't think the question was ever answered on who takes acquisition of maintaining the property as far as the glyphosate and the chemicals that are put onto it. I don't think that was ever answered. It was brought up, and we didn't get an answer. And I think the welfare thing is it's kind of the end. It's the health and I'm forgetting the other one, but welfare by definition is happiness is the second word in welfare. So it's pretty obvious that the welfare is not being taken into consideration because I don't think people are happy, and that just kind of mutes everything as far as I can tell. But thank you for my time.
Thank you very much.
Cody Jones, 111 Mockingbird Lane. I'll just keep it just to the modification permit. Being part of the process with the planning board, I feel that the proposed setbacks with 100 feet on the non-developed side, 150 feet on the developed side is more than fair, especially given the residential zoning district that it's in, and given the environmentally sensitive areas that it abuts to, especially the lot next to our house, in between 23 Dove Lane and 111 Mockingbird, there is a wetland in there. It's always wet in there. It's a swamp. And then given the property to the southwest, I feel that the proposed setbacks, the modification to it would be detrimental to almost everything in that area. Thank you for your time.
Thank you very much. Anyone else here want to speak? All right, so we're just going to run through the public comment we received via email since our last hearing. The other comments we did already read into the record, but they still are in the file. So we received a letter dated March 14, 2023 from Ann Salas in opposition. I believe we received another letter March 12th from Ms. Salas. Again, more information in opposition. We received a letter April 12th from Lily Raposa in opposition. We received a letter from Suzanne Powers in opposition. We received a letter from Richard Mell, Wednesday, April 12th, in opposition. We received a letter on April 10th from Debbie Lavoie in opposition. A letter on April 11th from Fred Hegg in opposition. A letter from Leonard Gillum, or Teresa Leonard Gillum, again in opposition on March 10th. We received a letter on April 12th from Rebecca Coverdale in opposition. We received a letter from Jean Cannon on April 10th in opposition. We received a letter from Deborah Caney on April 12th in opposition. We received a letter on March 12th from Kathleen Akulonis in opposition. And that's it. Additionally, we did receive...
Stephanie York on March 9th was at least it's in the record here.
Okay. Your mic's not on.
Yeah, from a letter of opposition from
Okay,
Stephanie
yep,
York
that's the
on
last
March
one.
9th.
Sorry, I missed that one. I believe that's the last one in the folder. Okay. And then we did receive these two documents today, which, Ann, are these in the record currently? Or I don't actually know who provided these. Do I know who? From the applicant? Okay. Which I'm not actually even, I haven't really looked at them, so I'm not even sure. I guess one of them is a emergency response plan, emergency operations plan, and the other is a decommissioning estimate.
It's the decommissioning
Probably speak to it.
page.
Oh, yeah, sorry.
Yeah, here I am. So sorry. Somehow my notes went
Can
missing.
you just say, introduce your name and address?
Ann Salas, 145 Mockingbird Lane, Marston's Mills. My notes went missing, so someone just brought me them. I want to speak to a number of issues that you're thinking about and discussing tonight. The noise, I'm going to speak without notes, but, and it's good that you have the decommissioning list, because 50 inverters appear on there, where only 2 are on the map anywhere. Okay? And it's...
I'm sorry. I'm sorry to interrupt you. Can you repeat that? I can't understand what you're...
Sorry. 2 inverters. 2 inverters appear on the maps. But in the decommissioning sheet that you have before you, you see 50.
Thank you.
Okay? So why are only 2 on the maps? They're both on 12 by 20-foot cement blocks with electrical equipment in the very fine print on the map. But there are 50 in the decommissioning list. And it's my understanding that inverters require transformers, and not one transformer appears anywhere on any of the maps or the narratives. So that's, and they're nor are they on the decommissioning sheet, right? So there are 60 pages of technical specifications regarding transformers, yet none appear anywhere. I read all 60 pages. And in terms of noise, both the transformers and the inverters, so that's 100 machines, all of them have noise emission levels that are at or exceed 70 decibels, which is the EPA level of danger. 1 hour exposure is hearing loss begins, okay? And the very fine print on those spec sheets is that those measurements are taken 30 feet away. Now, in the original maps in 2019, there were something like a dozen locations where batteries and transformers were. One of them was 40 feet from my house. And so why are there only 2 necessary now? And why do 50 appear in the decommissioning sheet? And why do none of no transformer, in spite of the 60 pages of specs, appear on the decommissioning sheet or anywhere on the maps or narrative. Okay. Additionally, what I found out about the transformers is that they require anywhere between 1,000 and 2,000 gallons of this FR3 cooling oil, and it is soy-based, but it is combustible. Their very own specs say that, and they require dry chemical to extinguish. Some not foam, but dry chemical. So I hope that answers some of your questions about noise and our concerns. These are all incredibly dangerous, highly volatile, high voltage machines. I mean, they're volatile. They come with stickers that say, the smallest transformers come with stickers that say, this is explosion resistant, but none of the other larger ones have such comforting things. So if I may sort of refer to my notes.
You're over 3 minutes, so try to wrap it up sort of quickly.
Quickly? Okay. Bridgewater, Mass. They were able to put an end to their 5-year legal struggle with TGA Solar in one beautiful moment. They saw that a proposed berm, was deceitfully shown on TGA's maps. And when they worked it out the way it should have been, would have encroached on a wetland. So it made the project impossible. That one thing finished it. 5 years of legal wrangling. And we have the same opportunity tonight because you can't fit 250 feet of setbacks in a 95-foot sole egress. There's a home on one side and the town watershed on the other. Now, the young family that lives in that home, I think, are as deserving as anyone else to have a 150-foot setback, which our bylaws stipulate should be undisturbed in perpetuity. It's my understanding that TGA wants to put the access road and the berm within those 150 feet. Even if you did that, you still can't fit a 150-foot setback, a road and a berm in a 95-foot space. That, to me, is a Bridgewater moment. This project is impossible, let alone taking care of the town property, which should really have a 100-foot setback, too. And on the town property, 150 feet away at the entrance, is a cell phone tower, okay? And that's a pretty volatile and frightening thing itself, high voltage. So this company sued our town to change our laws to include the illegal act of spot zoning. That's what the solar overlay on 810 Wakeby amounts to. It's spot zoning. These people make a lot of money, and we lose. Our lives are in danger from fire. We're so concerned about fire. The special permit application requires a hazardous materials list. They've had 7 months to do that, but they've only given a hazardous letter of assurance, hazardous materials letter of assurance, which lists nothing, basically denies the huge list of arsenic, lead, mercury, cadmium that's in every solar panel. If you look at your decommissioning sheet, you'll see 8,890 solar panels. That's a little more than half what the original plan called for, 15,000 solar panels to get the same 5 megawatts. Why is that? Why are only half the number of solar panels listed on the decommissioning? I think it's because it'll save TJA a couple of $100,000. There's not one mention of cement in that decommissioning list, and if 50 transformers and inverters all need 12 by 20-foot cement pads, there's going to be a lot of cement there. We talked about the 1,000 to 2,000 gallons of chemical of the soy-based oil, correct? Okay. It's deliberate deceit. And the litany of lies also leaves this town financially responsible for the cleanup in the event of a fire or a decommissioning, because only half the solar panels, half the machinery, and none of the cement is listed in the decommissioning plan. And there's no mention of hazardous waste disposal costs. And it's already a problem in the world. It's already acknowledged that solar panels are hazardous waste. And it boils down to this. If we enforce our bylaws, especially at the soil egress, the project is impossible. Our laws do protect humans, the same as wetlands, as long as we abide by them. And we're trusting you to take this opportunity with both hands and not worry. We're already being sued by them. But I think that the Judicial Court's decisions that give municipalities greater flexibility to not only protect the health, safety, and welfare, but they give municipalities, via zoning regulations, the freedom to preserve the unique characteristics of a zone. That means residential zoning for humans, not toxic, heavy industry. I think that the favor, really, of reduced setbacks is unthinkable, especially in light of all of this deception, which I've really only just touched upon in 3 minutes. Do you have any questions?
Thank you very much. I appreciate.
Thank you.
Is there anyone else who wants to speak before we close public comment? All right, seeing none. Okay, yeah, Attorney Ford, go ahead.
I just wanted to respond to one thing that I think is important. I don't think any new issues were raised other than the previous speaker made a comment about the decommissioning plan showing 50 inverters. We showed 2. It was the early conceptual plans that had 50 when we had batteries. I believe that's an error. I'd like Mr. Reale to address it.
That's correct. I apologize. But if you do look at the stamped one line from the electrical engineer, you'll see that there's not 50 inverters on that.
And we will correct that sheet, and I apologize to the previous speaker for creating that problem, and I can understand why she was confused between the 2 on this plan and the 50 on the decommissioning sheet. And it will be corrected, and we will resubmit it. Apologize.
So just to be clear, how many transformers? And
1.
And how many inverters?
Sorry, no, there's two transformers, and there's 6 inverters. They're both located on 2 equipment pads, though.
I'm sorry. So there's 2 equipment pads.
That's I think, where the confusion is. All the equipment is being stored on 2 concrete equipment pads. And that is reflected in the one line from the licensed electrical engineer.
Okay, so what is the storage fuel capacity on site for those 2 transformers and 6 inverters?
I'm not sure those specific transformers, but it does range somewhere in the range of 500 gallons per transformer.
So maybe 1,000 gallons total you're talking about?
And yes, and I'd like to clarify some other comments, was that comment that I made about the vegetable oil, the food grade vegetable oil, that's not my words. That is on their safety data sheet. So that's the company is saying, they're stating in their safety data sheet is primarily food grade vegetable oil.
And can you just address the noise with the decibel levels that the...
No. All inverters and all transformers are not within the setback, so they are at least 150 feet away.
Yeah, so that's what I wanted to comment on. In terms of the noise, we're not looking for any modification on those 2 pads. They will not be within the waived area.
So will those produce any noise, any decibels?
They will, but over that distance, the noise disperses. And in my experience, 100 feet is adequate to get it below Mass DEP's requirement of 10 decibels at the abutting property line.
But I think importantly, they're not within the area that we're seeking a waiver on.
I have a question. That's not a constant noise, or is it?
I mean, no, it's not constant noise. It's electric, so it's AC, so the frequency is going up and down, but that's the peak noise.
And is there any way to locate any noise emitting equipment to the farthest possible point from where it's going to bother people?
I mean, there is equipment you can do.
You show them on the map where they are,
Site plan,
so they get an idea? Yeah, can you show them?
Yep.
With your permission, Mr. Chairman, maybe I could have them show you where they are?
Do you want me to bring this up to you? Or you
Sure,
want
yeah.
me-
I'd like the public to be able to see it, too.
We can share it with the public.
One is located up here.
Mike, is that on one of the plans?
Anybody
Those are
have a
the two.
laser pointer?
I don't unfortunately, but I do have a full scale of it. Laser pointer too. Oh, is it? Oh, perfect. Do you mind changing the slide? I think this would be
It'd be good if the public could see that, I think, Mr. Chairman.
1 or 2, or sorry, 2 or 3. Actually, one more. Those are the existing conditions. Yeah, one more down. Oh, 2 more down, sorry. So we have one located on the north side and one located on the south side. Those are the 2 equipment pads that will store all the electrical equipment.
And so the distance from those pads to the closest developed lot is approximately how far?
It is, the southern one is approximately 150.7, and the northern is 150.6.
So is this,
We're not seeking a waiver for either one of those, Mr. Chairman.
is this a developed lot up here?
Yep, and
There,
that's maintaining the 150-foot setback.
And so you're anticipating that the decibel level from that distance to that developed lot will be
It would
zero?
be,
or-
I am anticipating that it would be under the Mass DEP requirement of 10 decibels.
Is there a reason that these couldn't be located further inland on, interior of the lot, or they have to be near the edges
Well, they
for
need to be
service?
accessible, so they need to be next to the access road. And unfortunately, due to the topography of the site, access road along the left side is not possible. Or the east, or the western side.
We don't have a plan. Is there fencing around these, or they just sit,
Yes, they're within security fence.
but not a stockade sound blocking fence or something? It's just a
No.
chain link? Could it be, or fire hazard, they say no?
I don't know if the fire department would have an issue with that or not. Generally, because of the distance though, and just the calculation for how sound travels, 150 feet is more than enough.
Attorney Ford, did you have other comments?
No, just to suggest to you the obvious, that we're not seeking a waiver on either one of those.
Okay. Ms. Salas, we can give you 1 minute, but I don't want to go any longer than that. Then we're going to close public comment.
Thank you very much. I'm just concerned about the access road. They want to put the access road within our 150-foot setback. I believe that's one of the, is that one of the things that you're asking for?
Yes, that's what we presented tonight. We presented at the last hearing as well. It's now increased from the last hearing from 12 feet. The fire department wants 20 feet. So there's 20 feet within the access. We're asking for a waiver on that.
So the Supreme Judicial Court ruled that access roads are an integral part of large-scale solar facilities, and they should not be included in our 150-foot setback, which are meant by our laws to be undisturbed in perpetuity. Thank you.
Thank you. All right, so I'm going to take a motion to close public comment.
I'll second that.
All right, so I'll make the motion to close public comment. Herb seconds. All those in favor?
Aye.
Aye. We don't have Aaron, but we have enough people, so we're.
Have we lost a member?
Yeah, we have to
I
wait.
believe he went to the bathroom. Yeah, we won't deliberate until. Do you guys want a 3-minute break? Does anyone need to go to the bathroom? Water? Nothing? No? Okay. All right, we'll wait till Aaron comes.
How does Congress do it?
They do it in alphabetical order so they know when to go to the bathroom.
Per the, I mean, they're both looking at, but they're all looking at it. Unfortunately, the water line did change before we submitted for site plan review. So I think that's probably part of the confusion on.
Yeah, we can get it correct.
The clock is totally wrong.
All right, yeah, that clock's wrong. We just realized that, yeah.
Make us feel.
All right, so that brings us back to the board to deliberate. Does anyone have any thoughts or?
I have a question. Does anybody remember, I could ask the engineer directly, but the gradient, which is the direction of groundwater flow, was that that was towards the site? Which means anything that was inadvertently spilled onto the site would not go towards the drinking water supply, right?
I don't remember off the top of my head exactly the groundwater flow, but I do know that all surface water that our stormwater design is to capture everything on site, and that's where it will be stored. So it won't be running off-site. It would be stored within 3 infiltration basins.
Yeah, I looked this up, I don't know, a couple weeks ago. I think I looked on Com's site, and I forget how I figured it out, but I satisfied myself that there wasn't a gradient away from the site.
No, it's essentially a giant bowl based off its historical use.
So anything spilled on the site, I satisfied myself that it wouldn't go into
Stormwater,
that.
yeah, all our stormwater calculations and our
I mean
design.
groundwater.
As far as
Everything
groundwater
permeated
goes, I
groundwater.
can't remember the specific flow direction of groundwater.
I just seem to remember that it wasn't a problem, that it was, I guess, towards the site? Which,
All be contained on site.
Yeah.
All the runoff has to be contained on site.
well, groundwater's something else, but
Yeah.
and then, I also remember reading in the recent material something about berms being removed or something like that. It could have been in public. That was in our material.
As I indicated, if I may, Mr. Chairman, just address that one specific issue. At site plan review, the DPW had asked that the berm be extended
Okay.
as part of the berm that's in the 150-foot setback. We've asked for relief on that, even though we think the planning board can allow it there, but we put that in our petition. Since we were here last, the DPW has indicated they've looked at the stormwater plan and they've dropped their request that the berm be extended. So there is no longer a request. And that's in the updated site plan that you have dated March 6 approval.
The site plan review letter. Mark, do you have a question, thoughts or comments? Again,
Yeah,
we're trying to
just-
deliberate here and make a decision.
Just a couple of thoughts, and again, I think one of the things that we consider when we're up here on the board is that, we're working within what is being asked in front of us. As my understanding, this is an as-of-right project outside of those modifications. Obviously, the public health, safety, and welfare, we're trying to take that into account as that goes, especially with noise, things like that, but we do have to have a demonstrated showing that there is, in fact, a real detriment there by engineering standards, by the sounds of it, 10 dB. I mean, my understanding is that a dishwasher is probably 40. Granted, these are much larger. I mean, I understand the noise, a widening of the road. I don't know that that necessarily changes the width of a truck or something that would be traveling that, or that it makes it any more frequent. I certainly can understand having a reasonable setback on the side where, there are properties with dwellings. The overarching overarching theme seemed to be the fear of fire. I find it very difficult to make full decision. I really would have liked to have had COM here to just, if it was for nothing else, than to be able to ask questions as they arose. But, what is their procedure for if there is a fire? My understanding on just personal research and whether it is underreported or not, it seems that solar panel fires are quite rare. Again, I'm not an expert. I'm just going on what I could find out there for information. Maybe one per. It's indicated that perhaps it's only one of every 10,000 installations. So, again, I think it's important that we think about what is actually in front of us. We don't get to decide whether this project goes forward or not. So that's my thought.
Yeah, I mean, I don't think there was any letter from Shane saying anything other than, they went out for the site visit. I mean, I personally wish there was a letter from COM Water saying we have no concerns over our water supply being affected there, but I get the sense they didn't want to put themselves on the line for that.
Well, maybe they did to the planning board. I mean, you don't know.
We haven't gone to planning board yet. But just at site plan review, there wasn't a lot on the letter here. Anyone else have any thoughts, or someone want to make findings, or?
I'd just like to point out, I've been out to that site, I forget which case it was, a couple of years ago it was, and there was supposed to have been, it wasn't 150 feet, but there was supposed to have been, for one of the older, I don't know if it's a special permit or a variance, but there was supposed to be a vegetated buffer. This owner of the site had cleared it right up to the property lines, and it is an eyesore, I'm sure. I went by there today on Wakeby Road, and it's kind of a little slice of old Cape Cod, because we used to always have stuff like this out in the middle of the woods, but it was clear cut, and I just think the history that the people here have with that site should be taken into account, not in our findings, but just in, the way Attorney Ford maybe could just, somehow help these people, to me, 150 feet of woods is a lot better than looking at that sand pit. And I don't want to sound like I'm, trying to, you guys will come by my house with tiki torches and stuff, like Frankenstein. But it's really an improvement, I would have to say, and almost as benign a use of property as there can be, if you just make sure that potential fires, potential contamination, and otherwise the well-being of the community is taken into account.
Yeah,
Are we doing that?
To part of your point there too, Herb, when I looked at the conditions, if this were approved, the setback, I didn't see a strong, I'll have to go back and do it again because I've read it, to remove, it says, to remove all the stuff. I mean, it's a junkyard. Right. I mean, it is a dump. I would hate to see that stuff moved over into, the existing salvage or whatever company it is or whatever. I'd like to see it all removed. And I don't know, it says here, hang on here, if I got the right words, if I got the right thing.
I guess what I'm trying to say is there's a history of,
I believe, right? Isn't it abandoned all?
Where are you there?
I don't even know where it is in this thing, but in the staff report, number 3, the above described development shall full build out lots, no further accessory structures. Given the size and coverage of the proposed use on site, all their uses currently enjoyed on the site shall be abandoned.
Well, they are abandoned now. I want them removed.
They're not. There's a live variance for a salvage yard, and you do have an opportunity to condition any approval
But
that go away.
On the property that we're talking about for this issue, isn't there a whole mess of, as you enter it, isn't there a whole mess of junk?
Yeah, it goes several acres back, and there is a live variance that authorizes a salvage yard on this property. And the zoning overlay district, and we'll get to this when we get to the planning board, requires that there be an abandonment of those uses as a condition of going forward with this. Right to your point.
Okay, so if we said, this is an if statement, I don't know if you can put an if statement in here, if it's ruled that special permit is withdrawn, I mean, I want it in here that stuff's got to get out of there. And so how do you do that?
Well, right now, it's operating as a junkyard.
Right.
And so this would take that
Right.
use away, and so it would be a violation of it not being a junkyard anymore. Right now, it's allowed. They can continue to do that.
Okay, so it's not their responsibility, it's the responsibility of the junkyard.
Right now, they can operate a junkyard, but we would be taking that away from the land use would no longer be
The
allowed.
special permit would.
But not this, not the modification.
Well, the junkyard is confined to that little southern area, very, very little. And
No, Herb, it goes back several acres.
It is all
Right.
there. Now, over here too, I think, but in here, right?
Right.
And so I'm saying,
But the modification would apply to the entire parcel.
well, it doesn't say in there that its stuff has to be removed, so that's what I guess what I'm
Well,
saying.
it doesn't say it has to be removed, but it could no longer be a junkyard, so it would be in a violation of zoning for it to be there in the
Well, then
building
why can't
commission.
we put say in there it has to be removed? If it's abandoned, okay.
We are
abandoned,
saying that.
well, the site shall be abandoned and removed. Okay?
The use is, like, we can only regulate zoning. We
All
can't
other
regulate-
uses currently enjoyed on the site shall be abandoned and removed.
So basically, it goes back to being either a residential property or a solar voltaic property, whatever else is allowed in RF1 or whatever this is.
I'm just saying 4. If they have to abandon it, then remove it too. How can you say number 4?
That's what the word remove means, removing any pre-existing variance, I believe,
Yeah,
not saying remove the junk.
Yeah.
That's
I mean,
not,
remove
we're
the
not
junk.
under our, but we're not
not- we're-
purview to do that. We can't demand that
That
somebody
would be the
clean up
building
their.
commissioner saying that what they're doing is a junkyard and that's no longer allowed, and
Yep.
saying, you need to clean up your junk.
All right, can we move, are we?
Okay.
I mean, someone wants to make findings.
I don't want to make findings quite yet. I just have a couple
Oh, yeah, go
comments
ahead.
here real
Sorry,
quick, sorry. So I'm going to reference Attorney Ford's notice to us this afternoon, and unfortunately, we didn't get it till a little bit late, so.
Not 4.
Attorney McLaughlin.
McLaughlin, sorry. I apologize. The Dover Amendment here spells out, and again, we go back to that word welfare. We've been over this once or twice or 3 times already today, but I find that using the property instead of a junkyard per se is Herb indicated, a benign type use, considering I don't find that to be accurate. You can't put this type of industrial type mass scale project and consider it to be benign to those that abut it. I find that to be a poor choice of words. I think that's, it's a dangerous precedent to set. So I am definitely concerned about that. I think the Dover Amendment protects us in that sense, that the welfare, public health, and safety are all factors here. There's been no indication that there's 100% guarantee that the public health and safety will be protected because of this project. I do not, we don't know. Obviously, we don't have a crystal ball to see what the future holds, and yet there is that threat that health, safety, and welfare will be disrupted by this project, 100% in my opinion. So therefore, I am against the modification at this point. I think we have enough grounds to stand on as a zoning board to, deny this modification, and it will then go to planning board for further appeal from Attorney Ford and his group. So that alone, and not even just that, but again, the definition of what the zoning stands for clearly states that the 100 feet is the number on the westerly side, 150 on the easterly side, and the modification is going to alter that requirement. And in my opinion, this project, if any project, should be bound to those regulations and buffers exist.
I agree.
I just,
Okay,
I don't,
you
yeah.
get specifics here, because that was the plea from the town council, is get specifics. So give us some specifics as to your position. All right, because I have a feeling like you.
Yeah, I know. I know. Well, that's the problem. Paul, I agree. And that's the problem, is that we do wrestle with these things. But again, at some point, we have to make a judgment call on how we stand. And so I think between the 5 of us, 6 of us, we should be able to come up with enough specifics. Now, I'm struggling with that, I guess, except the Dover Amendment does allow us, it does say, facilitate the collection of solar energy except where necessary to protect the public health, safety, and welfare. And in no presentation yet from the applicant nor the attorney have they guaranteed us public safety and health and welfare will be protected.
Specific, you got to get specific.
I can't be more specific than that. There have not, but they haven't been specific either in terms of protecting our citizens and their public health, safety, and welfare.
From what?
From fire.
Okay, that's
From
all right.
from the oil used to protect the transformers and the inverters. If there is a leak, again, Attorney McLaughlin indicated that any leak, any oil into the watershed is oil, regardless of what. And the gentleman that's representing the company said primarily it's soy-based oil. Primarily doesn't indicate to me that it's 100% vegetable oil. It says to me there are other ingredients in the coolant of these transformers and inverters. So again, primarily doesn't work. And Attorney Ford said there's 2 inverters, 1 transformer. Well, that was wrong, because the gentleman had to get up and correct him during their presentation. I don't have any faith that what we're being told is 100% accurate, which leads me to believe that until we're guaranteed public safety, health, and welfare of our citizens, this project is viable. That's my opinion. I'm not looking for a round of applause. That's how I feel. It makes me nervous. And again, and I do worry about this property as a whole, because I understand what it's been like. I don't live in Marston's Mills, but I understand what the issues are. But again, my opinion is that we, deny the modification request.
I just think, just one last thing, really sort of what Jake was speaking on earlier, more that I think of the concerns, both for fire and water. These are the two departments that we've heard really the least from. I mean, many of us have been through site plan review, and yes, they ask for access roads and they go through the basic things, but we have not really dialed down to the what ifs. And I think it's not 1,000 what ifs, but there is a fire. What is your protocol? There is a spill. What is the protocol or the feeling from the water department? There really has, and I don't know if they can even speak to that, but I think those are the things for me personally. If I could have some clarification there, I'd be able to make a better decision.
And Mark, I agree 100%, except we did get this memo today, and I'm not sure who presented this. This came from a public comment where she's highlighted here, section B on paragraph 4. And Attorney Ford, I think you maybe saw this, I'm not sure. I don't want to speak out of turn, but I'm happy to share with you. But it does say a member of management or an emergency response coordinator or his/her designee are the only persons authorized to speak on TGA Clean Energy's behalf to outside agencies, police, fire, medical services in the event of an emergency. That makes me nervous, because I'm afraid this gentleman is going to be nowhere to be found when there's a problem, right? I mean, who is that? Who?
From the fire department.
Of course.
There's no confirmation about fire department from that.
We don't know.
Yeah, I know, and I agree. There isn't.
Response.
Correct.
Correct.
Site plan.
Okay.
But I don't know who that person is. Who is the designee or the persons there authorized to speak on TGA's behalf when the emergency arises? Because that's what makes me concerned for the people that live nearby.
Okay, I don't know if that's different from any other industrial site.
Maybe not.
No,
Yeah,
why not?
maybe not.
Okay. So what I understand is that you need or we need, okay, something from the water department to understand what's going on
Sure.
here.
Yep.
And
If
something,
they have any concerns, if the
Right, yeah.
head of the Com Water is
Right.
like, oh, I have no concern about this, the land next door is not relevant.
Right.
Then I think it would be easier to say, okay, there's no water.
Okay.
And then we go to fire.
Right,
I mean,
then we
this
go
is
to
an
fire.
industrial
Right.
site,
right.
but it's not an industrial building that has fire sprinklers or any sort of.
Of course, and I don't dare speak for them, except
I don't know.
I think their response will be, I'm sorry to interrupt, Paul, but I think their response is going to be, there is no concern if there is no problem, right? But again, when the
Well,
problem arises.
we'll ask the right questions of them, okay?
It can't be hearsay. We need to, and
I
it
agree.
won't hold up further, and this will
So
end up
let
being
me
a project if
continue on,
not.
since I have the floor.
Sorry, my apologies.
Thanks. All right. If you get satisfied from the water department, and if you get satisfied from the fire department, what else specifically? You got to be specific now, because we're going to be sued
understood,
on this.
understood.
Okay?
Yep, well,
So
we
what
already are
other
sued, but-
specifically
Yep.
do you need in order to go one way or the other?
Specifically is, well, the boundaries are set, right? The 100-foot buffer is set for a reason. I didn't set the buffer. I didn't create it. It's in there. They're asking for a modification of that 100-foot buffer. All right? So specifically why, I think why was the buffer set originally if it meant
That
no,
was why
you know?
I asked Jim,
Yeah.
where that came from.
I agree.
Like, what
Yep.
was the
I know. And again, I don't, I can't
So
quite go.
let's say the buffer was 2,000 feet.
Yep.
Okay? The question is, if it was there because of noise, okay?
Yep.
And what we're talking about is vacant land in perpetuity, what's the issue?
Again, Paul, I'm not the one to make that necessarily.
You are.
Well,
You're
yeah,
Board of
well, yeah. So again,
What's the issue?
the issue is that I don't know when those zoning, district, when that was written in there, whether or not it was going to be, well, if it was intended to imply that it was 100 feet from vacant land necessarily, or is it 100 feet from?
Doesn't matter.
150 from?
That's the issue.
I understand what the issue is. I completely understand
I'm
what
just
it
saying,
is.
look, I don't want to go to court with this.
Well, we're, okay, yep,
I don't wanna
I
go to
get
court with
it,
it 'cause
I
we're
get
gonna
it,
lose.
I get it.
Okay.
Well, I feel that way, but yet,
a lot of money.
and you're right, I do feel that way. I feel like we're
So
fighting an uphill battle. We fought them,
No, we're not fighting an uphill, we're not fighting anything. I just want to know specifically from you, if we get the fire or the water settled, and now what you're saying is, well, wait a minute, it's the setback. Well, it can't solve the setback, other than there's nothing next door to it.
Well, I think it's a matter of if the setback affects fire and water, if these things being that close to this conservation land has a detrimental effect to the water supply, or if the water department says, hey, if these things melt down, it's going to go in there and blah, blah, blah.
But if they-
or if there's some sort of
Okay, I
PFAS. We didn't know
said-
about PFAS,
Wait a minute,
50 years ago?
I said, if we get clearance from them, okay,
So-
now what?
Then I think that helps us satisfy the, public safety and welfare, public health, protect public health. I would say water is public health, right?
Right,
Everyone in that area is drinking water.
Sure.
Coming from the aquifer in the ground there.
So do we-
Safety would be
so-
the fire department.
Right,
If, as one of our members of the public said, if there was a fire blowing that way,
Which could happen today, by
and
the
the
way.
fire department may say, hey, the conservation land there is whatever, trimmed enough and wet enough that the probability of a fire blowing through there is low.
right.
Or they may say, we have fires in there twice a summer and it's high risk.
Right, but Aaron's saying it doesn't matter with that, he thinks the setback ought to be the setback.
Well, that's Aaron's
Yeah, it's my take.
opinion.
Yeah.
Okay,
They were designed for a reason, in my opinion.
so we have,
We need 3 affirmative votes to pass.
Well,
the
Mr.
I would like to
Chairman.
request the information.
you have the
Okay.
authority, Mr.
So
Chairman.
you would like to request the information, so as of tonight, you would not be comfortable voting on it?
No,
I would
you
not.
have the right to continue this.
Yes, I know. I'm just getting a sense of where we're all at.
Oh,
And if
okay.
anyone else has any other information that they would like to collect.
Well, I have
Denise,
something.
because you're still sitting on this, even though you're not voting, you're not, so you could become a
My only
vote.
concern was the noise, because I remember when they put up something in the middle of Falmouth, how everybody complained about the noise. I mean, is that,
That was a win thing, right?
it was a win thing, but the point is these big machines, I mean, are they gonna, if we
Oh, your microphone's not on.
have a lesser burn to it, is that gonna make it really noisy? And if the startup and stop seems like that's even noisier than if it were a
I
continuous
think
noise.
that anything that makes any noise, correct me if I'm wrong, Attorney Ford, anything that makes noise is outside of the buffer. There's nothing in the buffer that makes noise. I don't think solar panels make any noise, correct? Okay. So anything that makes noise is in compliance with existing zoning.
So I just have a question. Mr. Ford, you indicated the zoning talking about the noise factor, right? Was part of the reason why the 100-foot was designed was solely because of noise. When was that written into the code?
November of 2022, last fall.
And again, I don't want to put you
I
on the
quoted from the bylaw.
Yep, I don't want to put
I can read
the
it to
writer,
you.
the author of the bylaw on the spot here, but I'm curious about what that was based upon, is noise being the only adjective added to a...
Yeah, absolutely, I can speak to that. So noise is specifically called out in the ordinance that is accurate in your section regarding setbacks. The ordinance is a whole document. It's not meant to be spliced by each individual section of site standards. The site standards include robust function for stormwater. So in analyzing where structures are set in a site, setbacks are included in your overall site standards for things like stormwater, things like emergency response. The reason why you have an emergency response operation plan is because that's specified here in the ordinance. It doesn't specify, the width of a road per se, because that would be very, again, site-specific, where our fire chief would come into play and has come into play and requested that 20-foot. So as a whole, the ordinance does specify a number of site standards. It does call out noise within the setbacks. It also does talk about no disturbance in perpetuity within that setback. And then it further goes on to talk about screening, requirements from the FAA, requirements from anything from the Cape Cod Commission, hazardous materials and products on site, an operation and maintenance plan so that the town, the building commissioner, the fire chief, and whomever else are necessary understand the interworkings of the site, a commissioning plan, so how it's going to come online, a fire safety compliance plan that is required, and these are all standards that would be submitted to the planning board for their review as well. Erosion and sediment controls and stormwater management plan, as I mentioned, and then lastly, as you guys have part of it, a decommissioning plan. So that's how that wholly came together.
Thank you.
So those requirements that you just said, those have to be answered to the planning board?
Absolutely. So any special permit, so any large ground-mounted solar within residential district, which this proposal is, would require a special permit, and all those site standards would be required to the planning board. And a submittal has been placed to the planning board.
If I may, Mr. Chairman, we have a hearing before the planning board in 2 weeks on a Monday night for a special permit. This is not an as-of-right project. And all of these other issues, including the issues that I'm hearing coming into what really shouldn't be part of this discussion, are all before the planning board. That's where they properly are. That's what the bylaw calls for. Only thing we're here for is that setback. And that section is tied to noise. It's clear in the face of the ordinance.
Attorney Laughlin, go ahead.
Thanks. I think there's been a lot of sensible concerns about what needs to be shown and demonstrated. The question is, where does that process take place? I believe, and I'm going to respectfully provide with staff's assistance, make sure that we get you a copy of the current ordinance as it finally emerged from the legislative process, and take a read through it. There was an awful lot of thought put into it, and so many of the issues that are popping up tonight as very genuine concerns are going to be properly before the planning board. And I think that process will play out at least as intensely as this does. And I think that the interests of the town, spurred by your concerns and and spurred by the language of the ordinance, will be well served in that examination. I would caution most respectfully that while some of these concerns that you raise are get close, I think it's a fair question to say in terms of setbacks, are there any special considerations that we need to be aware of in thinking about if we're going to intrude into that setback? Can we do so out to the within 15 feet of the line, or do you need to make findings after you perhaps hear from the fire department and the water department that perhaps some other number might be appropriate? You're dealing and focusing on the setback question, and I concur with Mr. Ford that that is a narrow issue before this board. But that is not to say that particularly things of relating to safety and fire safety, et cetera, particularly noise being the other one. The ordinance speaks to noise, and I think at the end of the day, we're to have a defensible position on that. It would be best that we try and focus on the noise issue alone. And I will leave to the petitioner the question of demonstrating to your satisfaction that how noise interfaces with distance and separation and so forth, whether by written materials or by oral testimony. But I think if we start going beyond noise, that is the way the ordinance is worded. I think we start approaching a point where we could run into problems in defending a decision. I am here to assure you that we will be working hand in glove with staff and with the planning board staff, membership to make sure that all of these issues, including such things as chemical disclosure and risk disclosure and so forth, have been really well vetted. So I commend your concerns. The job before you tonight is a pretty narrow one, and I think you've done a very good job highlighting it. And I think your concerns about water and fire setback and needing expertise on that is well placed. So thank you for entertaining that comment.
Attorney McLaughlin, but you still feel we need to find that it's protecting the public health, safety, and welfare, correct?
It's a question of thresholds, and I think the outline that Mr. Ford provided and that I provided does address that. I'd be more than happy to speak with the chair offline as we attempt to fashion a decision, and I can certainly work with staff on that point to address that. I will take special note of the concern about the welfare issue and give you a little more guidance right from the case law now that I know that that is a concern, and provide it back to you. Before I step away from the mic on an important but different subject, just procedurally, if you do entertain a motion to continue to receive input from fire and water and anybody else that you want, I just note for you that you close the public hearing. I think you have an option this evening while we're still in session to reconsider the decision to close the public hearing, so that, one, you can receive further input from others, and that the public will have the opportunity to comment on whatever material is presented by new witnesses coming before you. So as a housekeeping item, if you could take care of that, that'd be helpful. Thank you.
I appreciate you pointing that out. And so what sort of, are we...
So
are we at a time extension, Anna, on this? If we continue it, we must be, right?
We'll probably need a time extension. We've got April 26th and May 10th.
The applicant has to agree to a time extension, right? Or we have to render a decision before?
We are dealing with an unknown, and that is the judge's reception. Things are stayed right now in land court. I know certainly, and you can understand that the applicant's very anxious to get this resolved. I don't know how long it would take to get. I assume that, given the importance of this question, that you could perhaps get come folks in before you at your next scheduled meeting. I'd love to have the applicant agree to a 2-week extension on that, but that's up to them. Thank you.
So, I'm getting a sense you would, it sounds like we're sort of a consensus that people would like to hear from water, fire, any other things?
I don't need to hear from them personally, but
You don't want to hear from them? You don't
it's not that it's not that I don't want to hear from them, I just know what they're going to say. So I think I know what they're going to say. So I don't necessarily need to hear from them to make my decision.
I feel outside of the fire and water, the buffer beside a non-developed property, it's no issue for me.
So you
I
want
would
to hear from fire and water?
No, I do not.
You
I
don't?
do not need to hear from them.
Okay.
Because I believe planning board will vet that part of that, and it allows us to stay within the scope, very narrow scope of what the modification is.
Okay. So,
And
I was just going to say, would you want to make findings?
one other question before, if we're going to postpone this. Is there any way that the noise emitting, it's only two little locations that are emitting noise. Are those technically tied to those exact locations, or can those be?
Those are outside the area we're asking for a waiver on. They're in compliance with the ordinance.
Right.
They can't, I asked that earlier, they can't go further inland because they need access, or further in lot because they need access to them. If they were in the middle of all of the panels, they couldn't get the truck to them.
I'll make
Right,
findings.
right.
I think it's fine.
If you want.
That's outside.
It's just that you can still hear a
Paul, go ahead.
buzz, even.
You want to do that, Paul?
Go ahead, Paul.
Do we have to close our board or just go make findings? I don't want to screw this up now.
We were only going to open it back up if
It's
we
okay,
continue.
I'm on pins and needles. I don't
But we
want to go to
closed public
court.
comment.
Okay.
Not
all right.
continuing, so. Right.
We're not reopening public
No,
comment.
we're
Paul's
still
making
making
findings.
Okay, appeal number 2023-005. TJA Clean Energy as lessee has applied for a modification permit pursuant to section 240-8A3B, modification from section 240-44.2E3, dimensional requirements, and section 240-44.2F2 special permit provisions. The applicant proposes to construct a large-scale ground-mounted solar photovoltaic installation pursuant to section 240-44.2E3 of the zoning ordinance. The proposed setback for the solar array is 16 feet from undeveloped land on the westerly side of the property where 100 feet is required. The subject property is located at 810 Wakeby Road, Martha's Mills, Mass., as shown on Assessor's Map 013 as parcels 004, 005, and 052. It is located in the Residence FRF zoning district. My findings are that the application falls within a category specifically accepted in the ordinance of a grant of a modification permit. Section 240-8A3 allows for alterations for exempt uses. Number two, I find the Site Plan Review Committee found the project approvable, subject to zoning relief, in a letter dated February 10th, 2023.
I think, Paul, I think Attorney McLaughlin wants us to justify each of these of how we're finding this, correct? You'd like a rationale?
I don't want to prejudge it. Let's see how it goes. All right.
Okay.
Thank you.
All right, I'm sorry, let me take that back.
Sorry. To interrupt.
Find it, let me go back to number one. The application falls within the category specifically accepted in the ordinance for a grant of a modification permit. Section 240-8A3 allows for alterations for exempt uses. I don't have all the legal stuff. We have introduced the memos, and those are my findings, okay? The Site Plan Review Committee found the project approvable, subject to zoning relief, in a letter dated February 10th, 2023. I find that the proposed use shall cover over 10 acres of land for large ground-mounted solar, as well as associated improvements, and together with the required bulk regulations, this project utilizes nearly 100% of the site. Number four, after evaluation of all evidence presented, the proposal fulfills the spirit and intent of the zoning ordinance and would not represent a substantial detriment to the public good or the neighborhood affected. I would also like to say that in terms of specifically of the setback, there would be a substantial diminishment if the setback was not approved, and in terms might make the project economic. It certainly would harm the economics of the project. Does the decrease of 100 feet to the requested 15 feet interfere with, affect the health, safety, and welfare? No. In fact, it might improve the fire aspects if that land is cleared as a buffer from whatever it is now. And 3, is there any undue nuisance or congestion of roadways adjacent to the project and other surrounding properties? No. I find no. Those are my findings.
Mr. Chair, just a quick revision. The site plan review had a March 6th approval letter. They had revised it later.
Okay, so it wasn't February 10th, it was March 6th?
Correct.
So number 2 stand corrected to March 6th, 2023.
Okay. I guess I would turn it off and if you have comments, but I would add here that we're accepting the modification provision because the project would be substantially diminished. It would substantially diminish and detract from the project's usefulness of the development by reducing the project by, was it 3,300?
33%.
33%.
Energy production.
By
3,000 less panels.
Yeah, 3,000 less panels by respecting the setback, the required setback. And then additionally, I think we need to just add that we're determining that by allowing construction in the setback, we're not creating a public safety hazard to adjacent roadways or creating a nuisance to surrounding properties specific to the setbacks area.
Right.
Is that, I mean, do you want us to elaborate further?
No, I think that is adequate. I'll certainly invite comments from Attorney Ford if he wishes to.
No comments?
Those are my findings.
What's that?
No, nothing.
All right, so this is a vote on approving the permit based on the findings that Paul has presented. I have added to. Mark?
I'm in favor.
Oh, I guess we need a second.
Could I suggest that you vote on the findings and accept them before moving to approval?
Okay.
Thank you.
So Paul's presented findings. Do I have a second for Paul's findings?
I have a second based on those findings.
And so we're voting on the findings. We're not voting on approving the findings. We're just accepting them as findings. Mark?
I'm in favor as presented.
I'm opposed.
Paul?
In favor.
I'm opposed.
And I am in favor. So we have findings. Now we have to decide if we want to approve the findings.
Sorry, Mr. Chairman, is there any conversation regarding those findings, or are we just going to?
I mean, I think someone could introduce an amendment to the findings.
I don't understand finding number 4, where we say that is not detrimental to the public good or the neighborhood affected. So I just
Substantially detrimental.
Anyway, okay, I'm not baiting it. Go ahead.
No, I mean, it's open for discussion. I mean.
No, we've had the discussion.
No, Aaron could amend it to put.
He's not
amending. Or he could ask us to amend it. We could amend it to make it a stronger argument.
But don't argue it again.
I mean, I would say
make an amendment.
that specifically to the setback, we're not looking at the project as a whole.
I understand.
We're looking at just the setback, that the setback, allowing construction of the setback against a piece of land that will never be developed, and as far as we can tell, will have no environmental impact to that land, would not be a substantial detriment to the public good or the neighborhood effect.
Okay, so here's my argument. The regulation says 100 feet, correct?
Mm-hmm.
You're asking, the modification is asking to become 16 feet from an area of land that was designated watershed by the town of Barnstable Land Trust. There is no guarantee written in any of these in these modifications or these findings that says to me that 100% is a guarantee that the public good or the neighborhood affected would not be, a detriment. So to me, somehow that needs to be modified, in my opinion, to represent that if we're going to move a buffer that was designated to be 100 feet from land that was in perpetuity.
But we have to remember that buffer was created based on noise. The buffer wasn't created for any of those other things. It was created on noise.
Again, but as the planning board director or gentleman indicated, that you can't cut and splice the whole ordinance. It was protected, and is what is presented to us was spliced to noise. But if you read the entire thing in full, as Mr. Jim indicated to us, it includes everything else there as well, including...
Yes, we can splice this. That's our job.
Okay, well, I disagree. So I disagree on that. Yeah, which is fine. Move on.
Again, I think we need to bring this back to noise, that we're making a finding
Well,
based on
again,
noise.
so my opinion is these things make noise. So again, is the buffer there enough? I'm not a noise guy. I don't know, but
But anything that emits any noise is outside the buffer. Anything that makes noise is respecting the buffer, the required setback.
The buffer is now the buffer is not as much of a buffer because we're taking, 12 feet off?
No, but anything that emits noise is still being constructed with, not in this area. We're only allowing
I understand.
solar panels
Noise
in this area.
travels through clear air a lot better than...
I'm not here to debate this again, okay?
Yeah.
We've made our findings. The findings are approved.
Yep, it's time to vote.
The next step is to vote, so let's vote.
Okay.
So we'll take a vote so we have a motion to move the findings and a second to a vote. So we're voting on the findings as
Findings were accepted.
read. All right, so we're voting to approve the findings. Mark?
I'm in favor.
Herb?
I'm opposed.
Aaron?
I am opposed.
Paul?
I'm in favor.
And I'm in favor.
Okay.
So Paul, do you have special conditions?
I do. Anna, help me with the date here. 1 through 4,
Looks like February 23rd, revised March 1st.
March 1st, right? Yeah, revised March 1st.
And revised again today to
That's right.
reflect the current site plan review.
Right. Attorney Ford, are you familiar with those 4?
No, I'm not.
Okay.
I have 5 here.
5.
Do you want to read them, Paul, maybe?
Okay.
It would be helpful for everyone in the
You have a
public
copy,
that are
Ian?
here.
Maybe
Let's
just get a
get a-
quick copy, I'm sorry.
I have it right here if you want.
I'm sorry, Mr. Chairman, so the modification has been approved.
Well, we still have conditions to it. The findings have been approved as Paul read them in, and
So
yes,
have we voted on it or not? I'm just totally lost here. We already,
we're moving to conditions to
Okay.
condition it.
gotcha.
Could I perhaps, while Mr. Ford is looking at that, could I just observe, I don't think you've voted to approve, as I envision the
Approve the special
motion,
permit modification.
an affirmative vote would be to approve with conditions, and you haven't reached that stage yet, so if you could style it that way, we'll have a little bit more clarity on what you're voting on.
Okay. So, Paul, you're going to propose conditions. We're voting, and after you propose them, we'll vote to approve the special permit modification. with-
That's not, I'm sorry, there's clarification, though, Attorney McLaughlin. He just said to vote on the modification approval with conditions, correct?
But we need to state those
voted to
conditions.
state
We
the
haven't
conditions.
presented the conditions yet. Paul's going to present the conditions.
We normally,
Well, what I'm saying is I don't think you got a full motion in front of you. If you intend to add conditions to your approval, the best way to put it forward affirmatively is I move to approve the requested relief with the following conditions, and then up or down at that point. So just make it a cohesive whole. and go
Paul,
normally
if you
not
can
how it
read
goes.
if you can present it that way, please.
I want to check with Attorney Ford.
Attorney Ford, are you okay with the conditions, or? Yeah. So I make a motion to,
I make a motion to approve the modification.
I don't know if you're on.
Sorry. I vote to approve the modification with the following conditions. Number 1, modification,
hold it.
Sorry.
So as I'm reading condition 1, there was new information regarding the 150-foot setback. And I believe, at least as proposed, they would need to amend, or you would need to amend condition 1 to reflect that modification to the 150-foot setback.
Yeah, we reported at the outset that we, at the fire chief's request, made the road 20 feet. And so we're in the setback with the fire access road on the easterly side. I'm not sure it's covered in number 1. I think it was covered in the findings because Mr. Bernard said that, or in his motion, I moved to grant the relief as requested. And we requested any intrusion into that setback as required by the fire department. That was in our request.
Attorney McLaughlin, do we have a problem with the legal notice then? Because that wasn't what was requested in the legal notice. Correct? The public notice just says 16 feet.
We take a break for 2 minutes?
Sure. All right, we're going to take a 5-minute recess. We're going to go offline for a second. I'll just wait till we're back on.
Okay,
Thank you.
okay.
All right, we're back on the record.
Continue conditions on appeal number 20.
Attorney McLaughlin's just going to give us guidance here, and I think Attorney Ford may just confirm that we're going to move forward based on the existing legal notice.
Yes, we've examined the legal notice and as against particularly this slightly modified question about the access road and how that interfaces. And the notice is intended to alert people as to the subject matter. It doesn't necessarily have to anticipate every iteration or amendment that is forthcoming. And after conferring with the chair and with Attorney Ford, I believe the applicant is content with proceeding on the strength of the agenda item as published, and with respect to the relief that's being sought, that including this new wrinkle after the fire department's weighing in on the roadway, that he is content, that the applicant is content to move forward based on the notice that was provided. And if you could confirm that, thank you.
That's confirmed, Mr. Chairman.
All right, thank you. All right, so Paul, you are making a motion to approve the special permit modification
With conditions.
appeal number
23-005.
with the following conditions.
The
Go
following conditions are, number one, modification permit number 2023-005, a request for a modification permit pursuant to section 240-8A.3B, modification from section 240-44.2E3, dimensional requirements, and section 240-44.2F2, special permit provisions. The applicant proposes to construct a large-scale, ground-mounted solar photovoltaic installation pursuant to section 240-44.2E3 of the zoning ordinance. The proposed setback for the solar array is 16 feet from the undeveloped land of the westerly side of the property, where 100 feet is required at 810 Wakeby Road, Marston's Mills.
I think we should probably add there the
Right,
addition.
right.
The access road on the east.
How do we describe that? That's the.
And that the setback on the easterly side,
Side. The setback on the easterly side will include a
20-foot fire road, access
an
road.
expansion of the 12-foot to a 20-foot, which resides within the setback. Okay. All right. Number two, the site development shall be constructed in substantial conformance with the plan entitled Site Development Plans for 810 Wakeby Solar Project by Atlantic Design Engineers, Inc., sheets 1 through 6 dated February 1st, 2023.
And that's.
Is that?
Is that accurate? That's the most up-to-date, or there was a new one with the new road on it?
Site development plans. I think you updated that.
The site plan review was updated per the fire department's comments and the.
What was the date?
March 6th, Anna?
New plans. The date on the plans.
The site plan review approval letter was revised to March 6th.
March
That's
6th.
The date on the
site plan
plans, I think we need to
review.
reference the plans. Right. The site development plan for 810 Wakeby Solar Project by Atlantic Engineers, sheets 1 to 6 dated March.
Dated
Yeah,
February
it's the
1st.
same, except that the.
So the fire road is not shown on the plan as yet. We're awaiting the planning board. So the plan that you have is the correct one, but you need to add, which will include the 20-foot fire road.
Right. Atlantic Design Engineers, sheets 1 through 6 dated February 1st, 2003, and will include the 20-foot road on the easterly setback.
Right.
When the site plan review is completed.
Yeah, when the plan.
Or do we just say the plans that the planning board ends up approving?
Right, when the planning board.
Ultimately.
Okay, that works. Number 3, the above described development shall represent full build-out of the lots. No further additions or accessory structures shall be permitted without approval from the board. Given the size and coverage of the proposed use on the site, all other uses currently enjoyed on the site shall be abandoned.
And do you want to add there and return to existing underlying zoning, which would be residential?
Let's not confuse it.
Well, we're basically deleting the variance.
Let's not,
If I may, I'd suggest that if your concern is physical cleanup, address that. I'd prefer not to get into characterizing what the legal implications are of the residential zone or what have you. I think what you're looking for is physical cleanup. If I'm wrong, I'll be happy to help you further. Thank you.
yeah, so the number 4 would read, given the size and coverage of the proposed use on the site, all other uses currently enjoyed on the site shall be abandoned and equipment and
Any whatever.
non-relevant.
The site restored to natural conditions.
Yeah.
Okay, that sounds good. I can live with that. Okay. Okay, number 5, the decision shall be recorded at the Barnstable County Registry of Deeds, and copies of the recorded decision shall be submitted to the Zoning Board of Appeals office and the Building Division prior to issuing building permit. The rights authorized by this modification permit must be exercised within 2 years unless extended. That's my motion.
All right, so we have a motion to approve the special permit modification with the following conditions. Do we have a second?
Second.
All are in favor? Mark Hanson,
In favor.
Herb Bodenseek,
I'm opposed.
Aaron Webb,
I am opposed.
Paul Pinard,
In favor?
and I am in favor. So it has been approved as we read it into the record. All right, moving along, we still have
Is Anderson?
an appeal number 2023-008, Robert Carangello, maybe I butchered that, I don't know, has applied for a variance in
Mr.
accordance
Chair?
with, yes.
Mr. Chair, did you read in Anderson 2023-006?
Yeah, Anderson's
doing it now.
Sorry.
He missed it.
Where is it?
That's the one
6.
continued to April 26th?
Not telling you.
Where is it in mine? Okay. In appeal number 2023-006, Denise M. Anderson, trustee of the Anderson 77 Parker Road Nominee Trust, has petitioned for 2 variances from section 240-13E Residence CRC District Bulk Regulations and 240-36 Resource Protection Overlay District RPOD. The petitioner seeks 2 variances to unmerge Lot 1, 40,075 square feet, from Lot 2, a developed lot containing 43,915 square feet pursuant to the plan prepared by Sullivan Engineering Consulting, Inc. The subject property is located at 77 Parker Road, Osterville, Massachusetts, as shown on Assessor's map 117 is parcel 135. It's located in the Residence CRC zoning district. This was continued from March 22nd, 2023. And Attorney Schultz, I believe this is the one we continued. We're going to continue to the following meeting. I'll make a motion to continue it to, what's the next meeting? April 26, 2023 at 7:01.
Second.
All those in favor? Aye.
Aye.
All right, so it's continued.
Aye.
Aye. Sorry.
Moving on to new business, appeal number 2023-008, Robert Carangello has applied for a variance in accordance with section 240-14 ERC1 Residential District Bulk Regulations, minimum lot area, minimum front and side yard setbacks. Petitioner sold 4 Skipjack Lane to the current owners on November 20th, 2022, is responsible for obtaining post-closing zoning relief under the terms of the duly authorized escrow agreement. The parcel is within the Cobblestone Landing subdivision, was granted a special permit with certain waivers to 1986 of the town subdivision rules and regulations as shown on Book 5380, page 252 on the Barnstable County Registry of Deeds. In 2012, the owners of 4 Skipjack Lane and 10 Skipjack Lane created a new 607 square foot parcels and exchange them in order to resolve a driveway encroachment. Although the new lots remain in compliance with the 1986 special permit and waivers, they may not be in compliance with current zoning. Petitioner requests a variance or in the alternative determination that no zoning relief is needed. The subject property is located at 4 Skipjack Lane, Hyannis, Massachusetts, as shown on Assessor's Map 273 as parcel 085004. It's located in the Residence C1, RC1 zoning district. Sitting on this will be all of our regular members, Herb Bodenseek, Paul Pinard, Mark Hanson, Aaron Webb, and myself. Attorney Kenny.
It was only 39 when we started.
39 what?
Years.
I'm sorry?
No, I'm joking.
I was like, the clock?
Good evening, Mr. Chairman, members of the Zoning Board. For the record, John Kenyon, attorney with the law office in Centerville. I come before you tonight representing Robert Corangelo and his family regarding the property at 4 Skipjack Lane in Hyannis. Solar voltaic installations will not be a subject of this appeal, so you can put your minds at ease for a little while. This, the Corangelos referred to my office. They sold their property, and when they sold the property, the closing attorney raised an issue as to whether or not they needed a variance because of the change in the lots. Back in 2012, the Corangelos and their budding neighbor conveyed 617 square foot parcels to each other, which when you look at the, if you look at Exhibit D to my memo, I can't understand why the engineers drew the lots the way they did, but they conveyed the 617 square feet because the Corangelos had a shed, which they thought was in their back of the yard, and Mrs. Corangelo's garden, which they thought was in her yard back there, and the abutting property owner had a driveway which went across the corner of the Corangelo lot. When they came to us and told us that money was being held in escrow because they were advised that a variance was needed, I questioned that, and frankly, I didn't agree that a variance was needed. So my associate, Attorney Patrick Nickerson, reached out to Brian Florence, our building commissioner, and Brian's initial response was, yeah, a variance is needed. There was a land swap, created new lots, doesn't meet current zoning. So I dug into it a little bit more, and then I called Brian, and I said, you know, Brian, I don't agree with your opinion. And I said, were you aware that this was an open space subdivision? And he indicated to me he was not aware at that time that this was an open space subdivision. So he asked us to kind of pull it together and send him some more information so he could take a new look at it. My argument was, frankly, that these open space subdivisions are almost like a contract within the zoning ordinance where we set the size of the lots. You know, you show what you can do in a grid plan, and then you bring the lot size down, and you permanently restrict the open space. And so my opinion was this is kind of a contract between the town and the developer, and now the unit owners within the subdivision. And this whole stuff about meeting current 2-acre zoning doesn't apply because the zoning for this is set forth within the special permit approving the open space subdivision. So we pulled that together, and Brian said he would take a look at it, but then he was out for a while for a personal matter. It was a good one, not for me to announce to the public, but a good one. Brian was out for a while. Because of the timing, we had to file to get here because of the conditions of the escrow agreement. Our client stood to lose some money. So we filed, and then I asked my associate, Attorney Nickerson, to draft the memo, which he did. And it was he who discovered Section 240-17R of our zoning ordinance. And the Attorney Nickerson pointed it out to me, made me feel pretty good because it made me think that my opinion was right. And I don't know if you've had a chance to read 240-17R, but it says, an application for endorsement of approval not required plans to adjust lot lines between abutting owners not involving open space lot lines or right-of-way lot lines shall not be considered a modification of the subdivision or require notice to abutters, provided that such plan and building locations comply with the requirements of Section 240-17 herein. 24017 herein is the open space subdivision. The two lots after the 617 square foot exchanges meet the requirements of the cobblestone landing special permit, well, with the waivers that were granted for that open space subdivision. And I think 24017R says we do not need relief. So before I address the variance conditions, I guess I would ask you to kind of ponder that and let me know if that's how you feel, and if that's so, if you want to vote that we don't need relief, I won't have to address the variance conditions. And I will add that I did speak with Mr. Florence this evening, and I read this section to him, and he indicated to me, he said, I'm comfortable with whatever the board chooses to do. He also said if the board wants to hear from him, he would be happy to.
So he wasn't willing to just agree that you're in compliance?
It was on the phone, and I don't know if he was out to dinner or where he was, but it wouldn't be fair to him to say, hey, I need you to run your decision right now.
I'm pretty comfortable. I mean, the way I read, I have the E-code in front of me. The way I read it, yeah, I don't think we need to go for a variance.
Did you consult Attorney McLaughlin?
I'm sorry?
Our town attorney.
Yeah, I did not consult with him. I was trying to get a hold of the building commissioner, and
oh yeah.
I mean, I don't know what would our action be. You would want us to take a vote that we feel we have no
relief is required, and I can record that, and that'll clear up the issue for both of these lots.
So much easier. I mean, I think that's fine with me. Jim, do you have a problem with that from staff?
No, actually, I concur. Initially, when it was submitted to Anna, we had a conversation, and we agreed that we didn't believe a variance was necessary, but we recommended to talk to Mr. Florence further. So yeah, finding that you concur for the record, I think would be appropriate.
Okay. So I'll make a motion that we confirm that zoning bylaw 24017R applies here, and no relief is required based on the open space residential development bylaw.
Second the motion.
All those in favor?
Aye.
Aye. Opposed?
Thank you very much. Sometimes it helps to come in after a long hearing.
All right, wait, we still have more things we have to do. We're not just done.
Good night. Thank you.
Thank you. All right, so correspondence, Cape Cod Commission public hearing for Bourne Solar Project on Thursday, April 13th, 2023 at 1 p.m. at the Cape Cod Commission office, 3225 Main Street in Barnstable. There's a Cape Cod Commission public hearing for the NE Wind 1 Connection, Vineyard Wind, on Monday, April 24th, 2023 at 4 p.m. That will be held virtually. The Cape Cod Commission public hearing notice for the MV Reliability Project, NSTAR, in the town of Falmouth is on Thursday, April 27th at 1 p.m., which will also be held virtually. We had a consideration of discussing Paul's findings in research on what happens with continuations and withdrawals and things of that nature at the last minute, but I think we'll put that off until our next meeting, where we only have one item on the agenda currently. The clock says it's only 10, it's before 10. Our upcoming hearings are April 26, 2023, May 10, 2023, and May 24th, 2023. I will make a motion to adjourn. I need a second.
Yeah, I second Paul.
All those in favor?
Aye.
Aye. We're adjourned.
Well, Paul-